Thursday, July the 18th, 2013 meeting of the Tennessee Alarm Systems Contractors Board. I want to welcome the visitors that we have here today, and Ms. Vest, would you please call the roll?
Keith Harvey.
Here.
Vivian Hickson.
Here.
Karen Jones.
Here.
Kenzie Roberts.
Here.
Steve Tucker. I let the record show that Steve Tucker is not present, but you do have a chair, Madam Quorum. You do have a quorum.
Thank you. Has the board had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
I make a motion to adopt the agenda as it has been presented.
Second.
We have a motion and a second to adopt today's agenda. All in favor, voice with saying aye.
Aye.
All opposed? Motion is carried. Has the board had an opportunity to review the minutes from the May 16th, 2013 board meeting, and if so, a motion to approve?
The minutes as they were presented.
Second.
We have a motion and a second to approve the board meeting minutes from the May 16th, 2013 meeting. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Mr. Kilgore, you ready for your legal report?
First case is number 2013-005881. Here, anonymous complainant alleged that respondent was engaging in the sale and installation of alarm systems without proper licensure from the board. Respondent admitted that he had engaged in installation of less than 24 CCTV and alarm systems without being properly licensed with the board. Respondent states that he attempted to take his qualifying agent exam scheduled November 6, 2012, but a family emergency prevented him from doing so. Subsequent attempts to schedule the exam have failed due to no exam being available at the present time. Respondent engaged in the business of selling alarms prior to his scheduled test date, evidenced by price quotes submitted to potential customers as early as August 28, 2012, and has subsequently continued to engage in such business, evidenced by price quotes submitted to customers as late as May 2, 2013. Respondent, during a phone conversation with board counsel, stated that he has since ceased all alarm work and is focusing on only audio-video work until he is properly licensed to do further alarm work. My recommendation is authorize formal and send a consent order with a civil penalty for $2,000 per TCA 6232-304.
I think we ought to point out, in this particular instance, he brings up the issue of not being able to take the qualifying agent exam, but it would appear to me that he had probably in excess or approximately a year in order to take the exam, and so I think that that particular point was just not well taken on my behalf.
We have a motion by Karen Jones to concur with council's recommendation. Do we have a second?
Second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Microphone down so they can be sure to hear you. Is it on?
Case 2013-006841. Complaint alleges that respondent, while a designated qualifying agent for one alarm company, worked as a registered employee of another alarm company in violation of TCA 6232-304D. Respondent DQA states that he was registered as company number 1's DQA from November 14, 2012 until around January or February of 2013, at which time he transferred to another office operated by company number 1 as their DQA. However, documentation received in the board office in the form of employee applications for company number 1 show what appears to be respondent's signature with a date as late as March 8, 2013. Further evidence of dual employment is shown by documentation received on 2/25/2013 of an alarm employee application showing hire date of 10/22/2012, bearing respondent's name from company number 2. The branch administrator from company number 2 verified that the company was in process of sending respondent to training so that he could become their DQA, and they were not aware of him being employed as company number 1's DQA during that time. Respondent has since admitted via sworn affidavit that he quit company number 1 for company number 2 and was called the next day by company number 1 to remain as their DQA. Respondent states that he quit company number 1 for good in January 2013. However, this does not coincide with dates of employee applications from company number 1 bearing respondent's signature as late as March 2013. This is a violation of 6232-304D, and my recommendation, I'm going to recommend board's discretion.
Sure, what we've done in the past over there.
Are the civil penalty guidelines in here?
But I'd remind the board that they have statutory authority of up to $5,000 per violation, if that's the direction you'd like to go.
At this point, I think we're kind of looking at our guidelines with the desire to treat everyone as equally as possible. we really don't have anything, our guidelines to cover this as closely as some of the other situations we've encountered in the past. I don't recall having a case very similar to this quite a while.
I follow your narrative correctly. It's a period of 5 months that, starting November to March, November, December, January, February, March, working for both companies, correct?
I believe October 2012 is the, yes, and
Okay.
then as late as March, so.
I just missed that October.
Trained by company 2, even after he found out that company 1 wanted him back as their QA the very next day after he quit.
It is a little bit confusing, but apparently when he quit company number 1, he had already lined up a job with company number 2, obviously. And according to the DQA story, company number 1 called him back saying they really needed a DQA. And
Day.
right, the next day.
But he
and-
still continued training with company
right,
2.
Right.
Okay, I follow now.
The way we were notified, first of all, company number 2 had submitted just a simple employee registration app, not a DQA transfer, but then later on, a couple months later, we did receive a transfer for his DQA to company number 2. So, was employed by company number 2 in some capacity during those months.
Was he still the acting DQA of Company 1?
I believe the documentation would back that up. Company number 1 had not notified us of their DQA leaving or anything. He did later, but this is after,
I mean, after the whole fact,
right, after the whole,
Not between that 6-month period.
no, the transfer came very late.
I don't recall encountering a situation quite like this one before. It would appear, based on the indication and evidence gathered, that this person was maintained his status as a DQA for one company while in fact working as a registered employee for another company. For whatever reason and motivation. I would, Madam Chairman, I would suggest that we authorize a formal hearing on this, but that we offer a settlement in this particular case of $250.
$5,000 civil penalty. What was you basing that on?
On the statute, that's the
Yeah, statute
statutory
allows us to
authority
do that in any case.
granted.
That was not a recommendation, it was just a recitation of
Sure.
the statute.
Yeah.
I have a motion by Mr. Roberts to authorize a formal hearing with consent order for a civil penalty.
I second with discussion. Does the, are we gonna, is the 250 QA or the company? The QA that was riding the fence or the company, which company that was trying to get him away and to?
My intention here was the the person that's a qualifying agent, because it would appear to me that he was the one that had not followed through and was, Company 1 may not have been aware that he was working for Company 2. Company 2 may not have been aware that he was working for Company number 1. I would feel like the qualifying agent is the person that was misbehaving in this particular situation.
Okay, I got you.
Now, I will admit the $250 is rather arbitrary, but it didn't seem far out of line with some of the other penalties we've assessed for a first offense. I would certainly be open to some sort of amendment if you felt like some other.
No, it just seems like some of the qualifying agent penalties are greater for offenses than.
Some of our first-time offenses are in line with letter of warning, where someone has made, those are generally where someone has made an honest mistake or was unaware. I can't really believe that was the case here.
My second still stands.
We have a motion and a second to authorize a formal hearing and a consent order for a civil penalty of $250. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-009371. Complaint alleges that respondent alarm systems company failed to timely register alarm employees within the time prescribed by law. All employee applications were received in the board office on April 11th, 2013. The complaint was established based on the fact that the date of employment for all of applications in question was listed as January 29th, 2013. In response, respondent states that all of the employees in question were hired by respondent in January 2013, but all of them were hired out of state. Respondent states that at the point the employees were determined to be relocated to work in Tennessee. Applications were properly submitted in a timely manner. All employees in question, respondent states, arrived in Tennessee to work between April and May 2013, making applications timely received. I recommend a letter of instruction regarding properly completing notice of transfers.
Madam Chairman, I make a motion that we concur with the recommendation of our counsel here.
We have a motion and a second to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Number 2013-010551. Complaint alleges respondent failed to register an alarm employee within 30 working days of employment. Application for registration for employee in question was received by board office January 22nd, 2013. Employee's date of employment with the respondent was November 26, 2012. Respondent states that deadline was met as application for registration was mailed on January 4th, 2013. Even so, this is incorrect, as under the law, registration must be received by the board within 30 working days of employee's employment. Here, application was received far past the 30 working day time frame. Recommendation is authorize formal and send consent order with civil penalty for $100.
Motion to concur with counsel.
Harvey to concur with council's recommendation. Do we have a second?
Second.
We have a motion and a second to concur with council's recommendation on this. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Number 2013-008861. Complaint alleges that respondent alarm systems contractor company failed to refund all money due to complainant after service was terminated per complainant's request. In response, respondent states that all money was refunded and equipment uninstalled as complainant requested. Respondent states that complainant insists he never was credited money back to his account, but has never furnished requested information to respondent so they may verify that fact. This appears to be a contract dispute that respondent has attempted to remedy. Respondent states that the complainant has filed suit against them in small claims court, and civil court is probably the best forum for this type of dispute. Our recommendation is close.
Madam Chairman, I make a recommendation make a motion that we concur with the recommendation of our counsel.
recommendation. Do we have a second? Second. We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2013-010531. Complaint alleges that respondent misled complainant to sign a new contract by promising to pay off her old existing contract. Complainant has since withdrawn her complaint, stating that respondent has rectified the situation. It appears that this was also a contractual dispute involving two properly licensed alarm contracting companies, and it has been rectified to complainant's satisfaction. Council's recommendation is to close.
Motion by Ms. Jones to concur with council's recommendation. Do we have a second? Second. We have a motion and a second. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2013-009341. Complaint alleges that respondent was operating an alarm contracting company while not having a designated qualifying agent. Respondent states that he closed his business once his previous DQA quit. Respondent further states that he has not done any alarm business whatsoever since becoming licensed in November 2012 and that he has moved on to new ventures. Recommendation is to close.
There's no indication that this man or this person has been engaged in the alarm business?
They left. No, ma'am.
Okay.
I would assume that the contact with him would appear that this was a credible response.
Yes, sir. He's moved, it was based in Tennessee, and he's since moved out of state, and there's no indication that the business is in operation now.
Madam Chairman, I make a motion that we concur with the recommendation of council and close this particular case.
We have a motion by Mr. Roberts to concur with council's recommendation. Do we have a second? Second. We have a motion and a second to concur with council's recommendation to close this. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Number 2013-002781. Complaint was established when a routine mailing sent to company was returned as undeliverable, unable to forward. Board staff attempted to contact respondent by phone in order to verify the address information. Respondent employee answered the phone in a name other than the one under which they are licensed in. When asked why they answered the phone in another company's name, employee responded that was the quote company who purchased their contracts. Board counsel obtained a copy of the contract respondent company said they used. The contract contained only other company's name, which is not properly licensed in Tennessee, but that has made application with the Alarm Board office. Respondent states that this is their affiliate program, which purchases their contracts. My recommendation is to authorize formal and send consent order in the amount of $1,000 for doing business under a name other than the one under which the company is certified to operate per TCA 6232-316, Part 2.
Are they still in the same place, same employees, same everything, just different name, reorganized, sold
I
out?
believe that they are still operating in a partnership type or joint venture type situation with the other company that is attempting to get licensed right now. They've since updated their new address. This company has. That was what alerted us to there might be a problem, and when we contacted them, that was when it was determined they were operating under a different name. I think that since then, I've placed other calls to that number to this company, and they've answered in the name that they're licensed in, so I think it was just a miscommunication internally with the company. Some of the staff was confused about what name, what name they were to operate under, and I think they've since rectified that situation, but that doesn't detract from the fact that they were still doing business with an unlicensed company, which is against our statute to joint venture with a company not licensed in Tennessee. Right. that note, yes, the next case number 2013-011291, which is the next case on your sheet, is the other company that is attempting to get licensed, and my recommendation on that one is also $1,000 for the same violation.
Case 2013-002781, I'm going to concur, or make a motion to concur with council.
We have a motion by Ms. Jones to concur with council's recommendation. Do we have a second? We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed, motion carries.
Next matter, 2013-011291, same set of facts here. This company is attempting to get licensed, but they were apparently joint venturing with this other company that's licensed in Tennessee. My recommendation is authorize formal and send consent order in the amount of $1,000.
Madam Chairman, I make a motion that we concur with the recommendation of council here.
We have a motion by Mr. Roberts to concur with council's recommendation. Do we have a second?
Second.
We have a motion and a second to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed, motion carries.
Excuse me, Madam Chair, who was the second? Both of you spoke.
They both, I think Ms. Jones spoke first.
Okay, we're going to put down Ms.
Yeah.
Jones.
Case number 2013-009381. Complaint alleges that respondent failed to timely register 2 employees within the time allowed by law. First employee was hired on January 31st, 2011. Application was not received until October 17th, 2012. The second employee was hired June 30th, 2011. Application not received until September 17th, 2012. Respondent states that this was human error and new procedures have been put in place to ensure the same will not happen in the future. My recommendation is authorize formal and send consent order in amount of $1,750. As per our guidelines, it's $50 per month unregistered, and this was a total for the 2 employees of 35 months unregistered working.
Madam Chairman, I make a motion we concur with the recommendation of council.
We have a motion by Mr. Roberts to concur with council's recommendation. Do we have a second?
Second.
We have a motion and a second to concur with council's recommendation in this matter. All in favor, voice by saying aye. Aye. All opposed, motion carries.
Number 2013-009351. Complaint alleges that respondent company failed to register 10 employees within 30 working days as required by law. Employment dates of each applicant vary, but all applications in question were received in the board office far past the 30-day time period. The total months late are approximately 125 months for all employees. Respondent has failed to respond to the open complaint in writing. Our recommendation, per our guidelines, is to authorize formal and send consent order with civil penalty in the amount of $6,250 for failing to register the 10 employees for a period totaling 125 months.
Okay.
Is this an in-state company?
I believe so, yes, sir. I believe they have offices out of state as well, but this is a company, I believe this, if memory serves, this is an in-state company.
But I notice that you haven't included as any part of a recommended penalty the failure to respond to the complaint.
Well, I believe one problem there, and I know I mentioned it here, but I think that they are in between DQAs at present, so there might be some confusion as to who is handling that. So that might be an excusable reason for them not responding. I mean,
They're operating without a DQA, that brings
They're
up
under,
additional problems.
yes, sir, they're under an extension, which has been granted right now.
Madam Chairman, I make a motion then that we concur with the recommendation of our council in this matter.
So, has it been over 30 days in this matter? That they have failed to respond?
Yes, ma'am.
But they have a DQA, but this DQA was just granted an extension, correct?
They do not have a DQA right now. They're operating under an extension to find a DQA.
Company was operating
company.
without a QA, under an extension, to find one.
All right, we have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-004211. Complaint alleges that respondent is engaged in the selling and installing of CCTVs without proper licensure with the board. In response to the complaint, respondent states that it has only been operating for about 1 year and provided copies of a total of 9 sales contracts showing relatively low sales volume. The largest contract was for a total of approximately $2,500. My recommendation is authorize formal and send consent order with a civil penalty for $2,000.
Motion to concur with council.
Second.
We have a motion by Mr. Harvey, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Number 2013-011731. Complaint alleges that respondent company failed to register an alarm employee for approximately 7 months. Respondent admits to this mistake, stating that it was an oversight and new procedures have been put in place to assure this will not occur again. My recommendation, per our guidelines, authorize formal and send consent order in the amount of $350, which is $50 times 7 months unregistered.
Motion to concur with council's recommendation.
Have a second.
Second.
Okay. We have a motion by Mr. Harvey, a second by Mr. Roberts to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Complaint number, or case number rather, 2013-012081. Complaint alleges that respondent company failed to register an alarm employee for approximately 5 months. Respondent admits to this mistake, stating it was an oversight and new procedures have been put in place to assure this will not occur again. My recommendation is authorize formal and send consent order in the amount of $250, which is $50 times 5 months unregistered.
Madam Chairman, I make a motion that we concur with the recommendation of council.
Second.
We have a motion by Mr. Roberts, a second by Ms. Jones to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Number 2013-012071. Complaint alleges that respondent QA failed to timely submit transfer notice to the board office. Transfer notice in question shows an individual's hire date as November 1st, 2012, and was received in the board office on January 31st, 2013. Respondent states that the reason for this error was that originally employee in question was going to be hired and start in November, but due to a family emergency, employee did not actually start until January of 2013. Respondent had originally given the employee the form to physically submit at the board office and forgot to instruct the employee to change the hire date on the form. My recommendation is to issue a letter of warning regarding timely submission of transfer forms.
I make a motion to concur with council.
We have a motion, Ms. Jones, a second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed, motion carries.
Case number 2013-010611. Complaint alleges that respondent is operating an alarm company without first being duly registered with the board. Respondent provided our investigator with a copy of alarm systems contractor license number, which is listed for an Indianapolis office, which does not satisfy the branch office requirements for the office located in Knoxville. Respondent is also in violation for not having a separate qualifying agent for the office operating in Knoxville per TCA 6232-316F. And I'm going to leave it up to board discretion in this matter.
It's an Indianapolis company with
They
a
are
brick
using...
and mortar store here, or in Knoxville.
Right.
So that's considered a branch, but they don't have a QA for that branch.
And apparently they're using the license number
Out of state.
out of Indianapolis, which they keep a copy there in that local office, but that's not their actual license number. That's the Indianapolis office's.
How long they've been in business?
They can't do that, can they?
No.
Just since
They submitted for a Tennessee license?
no, sir.
Hadn't planned on it because they just provided their investigator with their Indianapolis license for that store.
But we don't have any indication as to how long that had been going on.
Oh, so the investigator was investigating, well, they were investigating the matter of operating without proper licensure, but for whatever reason, that wasn't provided to me.
To this, is there any way he could possibly call the investigator and see if they have that information, that maybe it wasn't included in the report, and us pass this and come back to it? Would that,
Like me to do just further investigation needed or further information?
I think it would help to satisfy the board's interest as to how long this company has been in business up there.
Well, why don't we just defer this particular item to later in our business session? If we feel like there could be some additional information gathered from the investigator, do you feel like that would be possible?
I finished my legal report and everything. I might be able to run upstairs and make a phone call and see if she has any information. I'd be glad to do that.
If we can't get that information today, we can just postpone it to the September meeting and give them an opportunity. Does the board have any other questions about this that we might need to get answers on in this interim?
I think the main thing is the duration that these offenses or apparent offenses have continued. If that would be possible, Madam Chairman, I would make a motion that we table this particular case and decision until later in the day.
Okay. We have a motion by Mr. Roberts to table this matter until later on in the day of our meeting. Do we have a second?
Second.
We have a motion and a second. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
For 2013-008091 and there are two respondents here. Complaint alleges respondent DQA failed to timely submit termination notices for 2 employees and transfer notices for 3 employees. Complaint also alleges that respondent company failed to timely register 1 employee within the 30 days.
Hold up, we don't have that.
Oh, I apologize.
Oh, that's
I
okay.
added that one, just...
We've got the next thing in our file. No, that's okay. The next thing in our file is cases for re-presentment.
And alleges that respondent DQA failed to timely submit termination notices for 2 employees and transfer notices for 3 employees. Complaint also alleges respondent company failed to timely register 1 employee within 30 days. Respondent DQA states that all of this occurred prior to him being issued a QA license, so therefore he should not be responsible for these violations as he was not acting as the company's DQA at that time. Upon review of the file, it appears the only violations are failure to register 1 employee, which is company's responsibility, and all others appear to have been addressed in a previous complaint against the former DQA. Therefore, my recommendation is a letter of warning to respondent company for failing to timely register 1 employee, and perhaps a letter of instruction to respondent company and DQA regarding transfer notices, termination notices, and there is an issue I'd like to maybe have the board address about who is responsible when there is no DQA in place. I believe our rules and statute are silent on that. I believe that the company or whoever's acting manager at that time, I mean, I understand there wouldn't be a DQA, but whoever's the responsible party for that office, perhaps.
I think it goes back to the company. Do y'all not agree?
It would have to.
So the DQA,
It would have to.
It goes back to the company because, TCA 6232 312C even states company failure to register employees. So
Right.
you can hold the company responsible. How long was this person employed without being registered? Who's listed as the owner of the company?
I would think that the whoever the executive officer for the particular company, somebody authorized to represent the company. I mean, that's really the only option you've got when you don't have a DQA in place, and they're within a time frame that's appropriate. Then notifying an authorized representative of the company, whoever that might be, could be the office manager, it might be the president.
In this case, I believe there was some confusion. The 3 transfer notices were signed by another branch office, which is like a town over for the same company, and it was signed by their DQA in an attempt to meet the requirements. So that's why I was recommending a letter of instruction. Maybe that way it could clarify for them how to do that in the future. We've had a previous complaint against this new DQA.
There has or has not?
I don't believe there has been, no ma'am.
Now, if I understand correctly, there's still an outstanding case that has not been resolved against the previous DQA. Is that?
I believe it has been resolved. I believe he's either has paid a civil penalty or is on a payment plan.
Okay. And what about the company?
A company has had a previous violation, but I don't think that a complaint was opened against them.
Madam Chairman, I make a motion that we concur with the recommendation of our counsel here, which would present a letter of warning to the DQA, and apparently would also provide instructions as to how to proceed in the case where there is not a DQA in place. They could be very highly appropriate. So then my motion is we concur with the recommendation of council.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed, Motion carries.
Thank you. I just have two matters for representment. Case number 2013-005601. The board previously authorized a civil penalty of $600 for respondents' failure to timely file 12 termination notices. I later discovered that there were, in fact, only 11 late termination notices. So I recommend that we accept the signed consent order with modified civil penalty of $550 to properly reflect the 11 termination notices that were not submitted timely.
Okay. Do we have a motion?
Motion to concur.
A motion by Ms. Jones. Do we have a second? And a second by Mr. Harvey to concur in this, with the council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
For 2013-004261, basically the same situation here. The board had previously authorized civil penalty of $1,800 for failure to timely submit 36 termination notices. It was later discovered that there were only 35 that had not been submitted timely. My recommendation is to accept the signed consent order with modified civil penalty of $1,750 to properly reflect the 35 termination notices that were not submitted timely.
I have a motion by Mr. Harvey, a second by Ms. Jones to concur with our council's recommendation in this matter. All in favor, voice by saying aye. Aye. All opposed? Motion carries. Okay. Certainly. Be in recess until 10:05. We're going to call back to order this July meeting of the Tennessee Alarm Systems Contractors Board. And I understand there's been a request that we move an item on our agenda.
Madam Chair, we'd like to introduce our Chief Counsel, Michael Driver, to speak to the board concerning some exams.
Okay, thank you. Mr. Driver?
Morning, everyone. Hope you all doing all right today. Appreciate you letting me come in front of you and talk for a minute. As she said, my name is Michael Driver. I'm Chief Counsel here with the Regulatory Boards Division. And as you all know, you've been without an examination now for about a little over 3 months now. And while we are in the process of trying to procure a new vendor for that examination, we're at a point I'd like to come before you and make a recommendation that y'all consider making alternate arrangements for that examination. Specifically, your statute gives you wide discretion as to what that examination is, the number of questions, the subject of that examination, and your rules again, well, and it does say after the application is complete that the board has to determine that the person's passed the exam to your satisfaction, and then the rules simply say that they have to meet all of the other qualifications for each classification they're in. And what I would recommend in this case is that the board consider, after the last vendor stopped giving the exam, we received, I believe it's 32 questions, the laws and rules portion of that exam. We did not receive the technical portion of that exam, and that I believe that this board could delegate to the executive director, Ms. Vest, and her staff, and whoever she designates to assist her with that matter, to, in the interim period until such time as we can procure a vendor to continue giving the exam, to give the exam essentially in-house so that the companies that are trying to come into the state and open up their businesses can continue doing business in that interim period and procure a qualifying agent license. If the board would consider that, I think what we would need is a length of the exam and what the pass rate would would need to be. I don't think the law or rules provide any particular guidance on that. I think Ms. Vest had mentioned 70% was something that was generally considered acceptable, and that if you all would consider doing that, I think it would help a lot of the applicants that are trying to come before this board to get their licenses. We have one such applicant. We have two representatives from AT&T Digital Life in the audience today who recently filed an application and were interested in this process, and again have recently filed their application for the exam and are asking the board to consider alternate measures. The board does not appear to have the authority to grant something on the lines of a provisional license, but you do have wide discretion as to the contents and type of exam given, and I think it would be worth consideration.
What is the status on the procurement of a new testing person?
I believe that we're still working on that. The last thing that I actually have seen or heard was contract has not been signed. If it gets signed quickly, it may be months before we can actually have an exam in place.
You're exactly right. The board does have wide discretion in its examination. The statute does require an examination, but the board has wide authority into the extent and the type of examination. If I understand correctly, what you are recommending is that the board look at alternative procedures. I personally think that's exactly what we need to be doing.
And that is what I'm here recommending before you today, and specifically my recommendation, and the most viable appears to be delegating to the board staff and whomever they may designate to assist them with that, to use the questions that were received from the previous exam to develop a new laws and rules exam, to test the qualifications of the qualifying agent applicants, and then to review the experience and other qualifying factors that are provided as part of that application process, to make a determination that each of these applicants is qualified to provide qualifying agent services in each of the classifications for which they have applied.
So what your request is for qualifying agents only, not across the board for registered employees?
That's correct. This is qualifying agents only.
Okay. And the test that you're deferring to, that the in-house staff could administer, would this cover only the laws and rules, or would there be technical questions?
It would cover only the laws and rules. We did not receive the technical questions from the previous vendor, and were we to be able to develop the technical questions, I do not think we could do so in a time that would meaningfully enhance this process.
Would it be proper for us to, or legal for us to provide a provisional license with the understanding that once this testing procedure is in place, that person would have to come back and retest completely?
There's not any statutory provisions.
Yeah, the statute doesn't speak to any provisional license, and I'm not sure. Well, I do not think the board has the authority to grant any sort of provisional license. You do have the authority, as I noted, to change the testing procedures and make those determinations.
I think your recommendation is right on target. I think that we need to examine that and decide how we want to proceed with that. It's unfair to companies and the industry as a whole to have a de facto block on qualifying agents being able to be licensed. Now, it's not something the board has intentionally brought about. It's just we're sort of stuck with that situation at this point. And I think we're going to have to, Madam Chairman, perhaps as part of the business today, we need to establish a procedure, some sort of an examination procedure. I know I have been through examination procedures in other states. There are a wide variety of options that would be available to us on that. But I think just out of fairness to the companies that need qualifying agents and to the industry as a whole, and for the protection of the people of the state of Tennessee, that we need to establish an alternative testing procedure. As distasteful as that might be, I think it's just absolutely essential that we do that until a more formal procedure can be established with a qualified testing agency. We can perhaps at some point during the day address that if you want to do that now, or whatever the board's desire might be in that regard.
Opinion of this?
Well, I agree 100%.
So
From what I'm understanding, you think that the 32 questions that we received back from them, and not the technical questions, if someone could pass those 32 questions, then they'll be able to install a fire alarm in a daycare center and save someone's life?
Well, all I'm speaking to is that what the requirements are in the law. I will note that qualifying agents are required to have at least 5 years of experience in the actual installation of alarms, is my understanding. And the law, as it is written, does not speak to what is required to be on the exam, and that's something that the board can determine.
Let me ask a question of our staff. If I understand what's being said here, we have a series of questions that are available on the rules, the statute, the rules, bylaws. The staff has these where they could be used as a basis for a written examination. Is that correct?
Yes, sir, we have them in our office right now.
Okay, good. Madam Chairman, let me suggest something, and again, this is not a direction that I had particularly wanted to go, but I think, again, and I keep saying out of fairness to the industry, that we need to have a procedure in place. I know that I have a number of licenses in various other states, and I know there have been times when I have had to appear before the board and basically was given an oral examination before the board in order to get that particular license granted. What I would suggest that we consider doing is that we establish a procedure today whereby the staff could give a written examination on the rules, the statute, rules, and regulations that this board operates under, and that then there be an examination either by staff or one of the board members, basically an interview, oral examination, so that these people could be granted a license if it was deemed appropriate by passing the exam. I hate to do that. I'm not a real fan of oral examinations, but I really don't see any other viable alternative. I would be totally unwilling to have someone pass an examination on the statute and rules alone and be granted a license in a very technical field in any one of the three that we or any one of the four that we actually oversee. So I would feel that appropriate an oral examination in addition to a written examination on the statute and rules. And I think one of the board members should be involved in that process.
do you want to put a timeline on this, that it's not a permanent thing?
Oh, I think only until we can get a qualified testing agency in place, and that should be done as quickly as can possibly be done. I'm just would be looking for an oral technical examination as a purely temporary measure, and I think we need to do everything possible to expedite returning to the written examinations we've had in the past. But I think the situation that we're faced with is we just need to do something like this because of what we're faced with.
Do we just not have room to get Proctor to do, or somebody to
I don't think it's a money issue at all.
They didn't understand they did not reapply or resubmit a bid for the contract, and they're having to find another company to proctor the alarm industry test.
Well, not just to proctor it, but,
$20,000.
No, that's not,
Develop the test.
yeah, they have to develop the
That's the
test.
problem,
It's
is
not
the
just a question of proctoring
Right.
it.
but, I mean, we're having to go from step one because it's an entirely different company that will have to formulate the test and so forth instead of the other company that already had it. But is that agreeable, before we make a motion and vote on this, is that agreeable to the staff that either the industry members administer an oral test or the staff members do that to show a competency in the field? Besides the rules and regulations being written, they have to have like an oral exam that Mr. Roberts recommends.
Sheriff would know much
That's
about
not
putting an alarm in.
what I understood. I think the direction I was looking at, maybe it was just me, but I was looking at taking however many applicants we have to take the exam. We have the facility to bring all those individuals in, and the staff administering the exam.
I think that'd be fine, but that's inadequate as far as determining technical qualifications, some of which are very highly technical, and that I would not consider an adequate examination process for someone.
Could it be worked out that the day that you were to bring these applicants in and administer this written test, that the board be available that day to administer?
All the board members are in the industry except for one.
Exactly.
Give an oral exam, you're going to have to give that.
Yes.
True. But, I mean, it wouldn't
Yes.
have to be a 2-3 hour ordeal. I mean, like Mr. Roberts said, I've gone through all type of promotion procedures where you go in and there's a standardized set of questions that you ask this person, and the industry people know this is the correct answer. They know what they're talking about or not, without it going into some type of narrative discussion. And then, you could actually allot a time frame on it and have the members here, and they all agree this is how they answered. We vote yes to give them their license. But I agree with Mr. Roberts. This is not just a registered employee. This is a DQA, and we're trying to do everything we can until the state can obtain a new testing procedure. But to just arbitrarily give somebody a DQA license based on rules and regulations, that doesn't quite, I don't think that sets well with the board without there being some type of a technical exam included in that. And if it be an oral, that seems to be the easiest, that I agree with Mr. Roberts' recommendation.
Would they be able to get any type of exam or QA license they applied for? Let's say I applied for Berg, fire, CCTV, monitoring. Well, once I find out that you're just going to give me a laws and rules exam, I'm going to come in and apply for all of them because I know I can pass that. But although I might not really be able to put in a fire alarm system or a burglar alarm system or an IP camera, are they going to be able to get them in any classification they like?
And I think if we had one or two, I don't feel the necessity for having the whole board meet. I would feel like that if we had one or two people that were licensed in that particular branch that the application was for, that we could handle that and do so in a reasonable and expeditious fashion.
But I'm just saying, if you had more than one board member available the day they administer the test, you could expedite the process with a standardized list of questions to question in the area that they're applying for, and you could have 3 or 4, if Mr. Tucker was available, you could have 4 oral interviews going on at one time.
Sure.
And have everybody in and out while some are testing, some are being interviewed, and be done with it in one day.
Yeah, I would think so.
Let me ask a question. If you're going to develop a set of questions for an oral exam, why could you not just put that in a written exam?
I think
I don't know if they would
I think you'd
accept
have
the test questions as being statistically correct or whatever if you had it in written form, whereas if you do like an oral interview, you could, I don't know about the legal technicality on that. Mr. Driver, I mean, could you
The board can, that's within the board's discretion. The board can decide what type of exam. We could give an oral exam with one question if we chose to do so. That's the board's discretion.
Yeah, well, and the statute does say, the examination may be written or oral. I will note, the questions obviously have to be reasonably related to the field that you're testing in and should be directed at determining the person's
Well, I don't think that would be an issue
qualifications.
at all. I think that's what we're trying to get at, is just, instead of a test on the general rules and policies, you are going to have a test specific to that area that they are testing for.
And I think we could generate a written exam. Staff has indicated that they could reasonably prepare a written exam on the rules, the statute rules and regulations. And I think that would be an excellent thing to do. And then follow that up with an oral examination that would be significant to the particular category in which the application is being made. And I think we could do that, again, with one or two people. Could be done in I know I've sat through a situation such as that in Arkansas. I did the same thing here with the General Contractors Licensing Board, where I actually sat down with a board member and went through it was as much an interview as it was an examination, but it was relatively thorough. There were questions asked and of course subsequently answered, and that's the way it was done. And I think we're going to have to do something like that. I think it's the only reasonable direction we can go, since we don't have. That would give us a partial written exam, would give us a partial oral exam. It's not ideal, but I think that's one of the few options that we really have at this point.
I agree. Under the circumstances, it's going to prevent this stopgap or this ceasefire, whatever you want to call it, that's going on right now, where no one can get their license, but it's still going to make the person applying during this interim period prove that they are qualified to hold that license.
So if I'm understanding y'all correctly, and I want to, that you would go forward with the board staff giving the written exam on the laws and rules portion, and then each applicant would
Have an
do
oral examination in the technical field.
with one member of the board who's licensed to, as...
So you've got 4 licensed board members.
Right.
The fourth one is not here today, but you actually have the 4 licensed members that would be qualified to administer an oral exam to these people, because I think everyone here is qualified DQAs. So that it's not like you have a registered employee quizzing somebody for a DQA or a QA.
I think that's a reasonable procedure to go through to
I agree.
Examine the technical qualifications. Like I say, it's far from ideal, but we've just gone, I feel like, as far as we can without some sort of examination process. Basically, just have not been able to issue any QA licenses because of the block we've had in the examination process. And
How close does it seem to be in negotiations?
She said that it's going to be possibly September.
I'm going to tell you, just from experience, we may not have an exam in place.
I think it's a reasonable assessment. If you were to issue a contract, tomorrow, it could be a period of several months while they develop the written examinations appropriately. So, yeah, I think our staff's
I think
right
it
on
should be
target.
done, to where it doesn't put too much extra workload on y'all, that you're not going to administer this once a week, but you send out ample notice, that we're going to do it on this date and possibly 2 to 3 dates, depending on the time frame until this testing is completed, and coordinate it with when the board members could come in for that day, if, it requires more than one day. But, I don't want to see y'all, because y'all are already terribly overworked, and these people work every day. But make it to where, you put ample notice, and then that day they come up, they do the written, they do the orals, they either pass or they fail. So has,
Over in California, and you're talking about Nevada and Utah and may not want to travel here to take these. I don't
We're
know.
sorry, but
It's licensed that bad.
Do we
then.
have the authority to charge somebody for an exam?
No, there's, the board has the statutory authority to charge for exam, but no rule has been adopted as to what that fee would be, and there's no basis to charge the fee without a rule to that effect. And
Well, we could ask people to pre-register just so we know how many people will
Yes.
come
Yes.
for that law and rule setting and then schedule.
why wouldn't you coordinate it where they're here the same day?
Yeah, that's what we'd do if people are
talking
coming
about 8
to
hours.
take an exam.
Yeah.
And again, I'll use the experience I had when I was making an application in Arkansas. I had to fly, in order to get my license, I had to fly to Arkansas, stayed overnight so that I could meet with the board the next morning. Sat before a board, as I recall, it was a 7 or 9 member board. In that particular situation, there was no written exam, it was just purely an oral exam. They all asked me a series of questions, which I responded to, and subsequently they granted my license. Now I'm not proposing that we follow that exact procedure, but I'm just saying that was what I had to do in order to get my license in Arkansas. I would think that if we had applicants that were coming to take the written exam, we schedule that on a day in which we could provide the oral examinations in the same relative time frame, and then either agree that they passed both portions of the written and oral examination or did not.
Would that require a public meeting or? Notice, but does it have to be at a board meeting?
It wouldn't be a public meeting. It would not necessitate a board meeting.
Exam process.
Yeah.
But I mean, if you had, at the most, you say you would have 34, I think you said right now, and you already have all of the experience and so forth at the point when you administered. Right, but I mean, you can do a lot of the background work ahead of time to say this person is or isn't qualified to test. And then once you do, if you're allowed to say 20 minutes per applicant and you've got 4 board members, you're going to be through in less than 3 hours with the oral interviews.
Well, and something that would likely need to be determined up front is how long should the oral
I
examination
think 20
be?
minutes, normally 20 minutes is about an accepted time, for an oral interview, but it's up to the board member to keep the person on track and not let them railroad it and take, 20 minutes on one question, but they're going to have to be in control and get the answer and move on with understanding if you take too long, you don't answer the questions, it's going against you. So that they don't just take control of the interview, but I feel very confident that these board members are capable of doing that.
Should you go down the road of the oral examination, like it sounds like you are, it will probably be necessary or at least advisable to create some written record from the board member that performed the examination of each individual
that would
stating.
become, you'd have a checkoff list. Did they discuss, did they hit on this point, that point, adequate yes or no, and then that would become a part of the file that showed, yes, they showed competency in this area. But the oral interview, you would have a written report, just a short thing on each person, yes, they did or they did not, and then you would be able to hold that board member, well, what was it about them, yes or no, that they failed or didn't, or they passed?
Well, would you consider taking any of those questions?
Say yes.
If we've got them available, that would be ideal.
Yeah.
Well, we don't have the NTS questions, but I think they might.
Well, like I say, these companies are in the business to write test questions, know that they've been, that they can be, for lack of a better word, they can be tested in court and passed for being a fair and permissible question. And I don't see a problem if NTS would turn some of those technical questions over, that those be used because they've been used in the past.
There are many questions
Challenged in court's the word I was trying to think of.
in the back of your reference books that Prometric required you to take in, let's say, 4 different reference books and it was open book exam, there are many questions at the end of each chapter that could be pulled by staff.
What we need is
If you want my books, you're welcome to have them.
books that we've been using for exam references and utilize those.
If you can't get the questions,
CCTV, which you have a copy of in your hand.
if you can't get the questions from them, then that would be an alternative source for questions, yes.
I've got I've got 4 of the old books, and I've also got 4 of the new books, and you're welcome to use them and pull any of the questions out of each chapter, which would be,
Wouldn't we need to be consistent?
Well, yeah, each day you'd have standardized questions.
off of them.
You'd have standardized questions for each of the
I believe that's
classifications.
something we probably could
Yeah.
develop, yes.
I think so.
That's what the board said.
I think that's would establish a procedure, and again, I am distressed that we do not have a more formalized examination process available, and I think that we're just obligated to move forward in some direction, and since that's the only particular direction that I see, again, I'd be open to other suggestions. But that's the only one that appears visible or viable at this point. That would be something that could be done in fairly short order. I'm talking in terms of a couple of weeks rather than a couple of months, because we've got industry members that need to be operating within the statute and are unable to do so at this point because of this this examination blockage. Let me.
Get in a motion.
You want to put it in motion? That's what I was going to suggest.
Put it in a motion.
So, Madam Chairman, I make a motion that our examination process on a temporary basis until we can have a vendor that would provide a written testing procedure similar to what we've had in place in the past, that as a temporary measure, we authorize staff to prepare a written examination on the statute, the rules, and regulations, which would be a portion of a written examination, that the technical portion of the examination in each of the classifications for which a QA may be making application, that those qualifications be determined by an oral examination that would be performed by a board member who was licensed in that particular classification which was being examined. I would then state that the combined written portion and the oral portion of that examination process be combined to either grant or deny the necessary examinations for a qualified agent.
What percentage would you put on the written and what percentage on the...
I wouldn't establish a percentage at this point. I just, basically, I'm just trying to put in a formal motion the procedure that we would follow.
I do think, and not necessarily on this motion, but by the end of it, we would probably need, for the written and the oral exam, a length and what the pass score is. And that, again, I understand you're setting out the procedure here, but I think we would need that in order to go forward.
Well,
in a reasonable way.
we're just going to pass the motion on a temporary procedure to
Right.
get this.
Establish a
Follow that
procedure, and then
meeting,
there'd be a number of details that have to be worked out, and I think we could do so. Once the board's authorized a procedure, then I think we could work with staff to work out appropriate details. One of the things I would emphasize is this strictly be a temporary interim measure until we can get a more formalized testing process back in place as quickly as it can possibly be done.
And something Vivian touched on earlier, would you, when we get a test proctored by someone, back in and sit
Can't do that. We don't have the...
Can't do that, either you give it to them or don't give it to them.
You know, this would be the only test that they would be facing. If they got their license then, there would not be any subsequent requirements to come back in and take another test. That's the technical portion now in this section of it, since they're... Right, Mr. Driver?
That's correct.
Okay.
I understand what's being presented here, and I guess I understand the relevant difference between an oral purpose of adding that workload.
They don't have the technical questions available to them right now.
I agree, but we're going to develop those for an oral exam, are we not?
That's correct, but you're not as, and correct me if I'm wrong, Mr. Driver, you're not as bound by a challenge in court on an oral. I don't think it's quite as challenged in court. And that's been my experience.
I honestly would have to look at the case law before providing you an opinion on that, and I apologize for that.
Not a great of a challenge. If you can show consistency in the questions that you're asked, and you can show consistency in the answers provided, if they certain elements of that question, then you're pretty good. But if you start putting a technical question in writing, then you have a challenge. I mean, we have a term, I apologize. The gentleman, yes, sir, I'm sorry, I wanted to call you Mr. Manchester, but, because we discussed Winchester, Manchester today. Do you see what I'm saying on the technicality, if you have an oral exam and they tick off certain elements versus the written exam? I mean, that's been my experience with testing procedures in the past.
I haven't looked at the law on testing procedures in a long time.
I know police departments have more leadway in writing their own oral interviews than they do where they have to send pretty much out all of their written exams to a testing company like they do to ensure, the challenge in court on if supposed to challenge it.
For the record, I'm Dick Lodge with Bass, Berry & Sims here for AT&T Digital.
You, Mr. Winchester, I'm sorry.
Yeah, and I think the flip of that is the risk of subjectivity in an oral examination that is not present in a written examination.
But like I say, if you have all of the board members have the same list of questions that they ask in that particular category, and there's boxes they check off, the particular hot key points that the person should have knowledge of, and they click, they check that off, then I think, you could show that each person was treated the same and received the same question.
You've always got the possibility of a challenge. If someone was not deemed to have passed an oral examination, then they're going to be unhappy about that, and you're likely to have a challenge. Yeah. But and I think we'll have to deal with some of that. But my concern at this point is for the folks that are qualified, that are entitled to have their license issued, that cannot happen at this point through no fault of their own, nor to reflect unfavorably upon their qualifications. I think we need to go ahead and move forward with a process that would allow us to deal with the 70 or 80 or 90% that are entitled to a license and are qualified for that license, and then whatever percentage remains that feel like they're qualified for a license but were not deemed to have passed the examination for one reason or another. We'll just have to deal with those.
Well, if
I
the
ask
oral
a
interview,
question? Yes.
Could you not have the written exam and then call it an oral interview?
Certainly you could.
Yeah,
but you would have your interviewer's notes that would become a part of that person's test
It would be
file.
an exam. It would be an oral interview by board members.
Distinction between an oral interview and an oral exam is kind of a fine line, and I'm not sure exactly where
But
that
the
would
notes, the interviewer's notes would become a part of that candidate's testing file to justify their vote of yes or no, that if it was challenged in court, you could pull the interviewer's notes and show why they were denied or why this person was approved. I mean, it's not just...
Like we're complicating a simple issue, but that's just my
It
opinion.
gets complicated when they start challenging.
Basically, my motion is that the board establish this process. Now, again, there'll have to be some amendments made, but the motion basically would establish a process to allow for a combination of written and oral examinations.
I'm still confused. I'm like Keith. So what you're saying is if they pass the laws and rules section, which will be written by staff, and then they come and sit for a so-called oral examination, interview, what have you, and we're going by a list of questions that either the staff or we have come up with, I don't know who, but anyway, what determines if they get their license, if they pass your written laws and rules, or if they pass our quiz of do you know what you're doing?
Well, we just said today is to establish a procedure, and then we'll move into the weighted portion, if it's a 30, 70, 50, 50. Today, they're just wanting to get the procedure in place without signing the percentages. Is that what you said, Mr. Driver?
Well, and
Or if you want to move on into
the percentages and all that, I don't think we can go forward with developing the process.
Well, I agree, but, you kind of wanted to put it down the road, but I agree. You can have this temporary procedure, but you are going to have to sign weights to each of these two sections in order to show, is it 50-50, 60-40, whatever. And, even if it's 5 questions to the person and 32 written questions, you're still going to have to come up with the number of questions and what weight that portion of the test carries.
Right, yeah, and I mean, I'm just throwing things out there. Obviously, it's the board's discretion, but just if you did the 32 written questions, if you said what we want to do is use all 32 of the written questions that we receive, and the person has to pass 70% of those questions, which I think would be 22 questions. I wouldn't swear to that. But, and then they have to go in front of a board member, do an oral examination, addressing each of classifications as which they are making license, and the board member, you could say, makes a determination as to the qualifications. You say assigns them a score, again, greater than 70 on the oral portion. Again, you have some problems, I think, grading the oral examination portion of it. It would be a determination, that board member's determination as to whether or not the person performs sufficiently may be the best way to caption.
I think it's exactly the way we would have to proceed.
Have it a pass or fail, not even assign it any type of numerical value. The written test would have a numerical value, and then the oral review would be pass or fail. Right. And if they fail the oral review, then that makes the test null and void.
Right. They would just have to pass each portion of the board to whatever is determined to be sufficient.
I mean, I have no problem with that at all, if that, you want to make it a pass or fail.
Again, that would be a procedure we'd set up. Basically, the motion would be to allow this sort of testing procedure, which I think is a reasonable one given the circumstances.
What happens if they fail the oral part?
That's what we said. It'd either be pass or fail.
They
fail.
Then they don't
get a license.
Okay, so they come back. Are they going to come back to retest?
They could.
If you have another retesting date of this procedure, if not,
I mean, that would be only fair if for some reason a person did not pass either the written portion or oral portion of the examination, then they would be allowed to retest it, just as they are allowed to retest with the process we've had in the past.
Yeah.
Sure. And I think we would want to, just as a matter of an internal procedure, set up so that if they passed the written portion and did not pass the oral portion of the exam, that a retest would be under a different, or with a different board member. I mean, it would just seem a fair way to deal with the process. Again, I'm just trying to set up, one, a process that we can move forward and grant licenses that are needed. Secondly, I want to set up a process that, and I think we need to do it internally, that would be fair and equitable to anybody that was going through this testing process, so that everybody's treated fairly and equitably.
And, like we said before, if it's necessary to have more than one testing date, say they weren't successful on that first testing date, they report back to the second scheduled testing date, if that is required.
That'd be their option. Yeah,
Well, yeah.
they could, for a retest.
Right, but what I'm saying is, instead of having the board members running back and forth to say, okay, we got 2-3 retests a day, have it on the second date of the written exam, and then they come back on that date.
We'd have
Right.
set up some administrative procedures for doing that.
Yes.
But again, the motion would be to allow this sort of a process on a temporary interim basis.
We always had study sessions for Prometric. We had a bunch of us get together and go over questions and look at the material that the candidate was able to carry in, and why couldn't we do that and make our own questions and not have to worry about having an oral exam?
We may have to do that
If we
ultimately.
picked our own questions out of the study material, then there's no sense in us running. Already picked the questions.
I think you'd have to set up a date to do any sort of testing where you'd bring in everyone or the people that would be available on that.
Written test questions together, unless...
Well, we just had one big meeting, and we were all divided into groups of 4, and each...
Yeah, it was test development. And yeah, we'll probably have to go through that process again later on.
Why couldn't we have our own test development, is what I'm saying.
I think the point is to move as quickly as possible.
And I think the motion that I've made would authorize that process to move forward, and I think we could do so fairly quickly. We should.
So, Keith, did you want to say something else?
No, I guess I still fail to see the purpose of the oral part of it. I understand it. I agree that we need to do something. We need to do it quickly. We need to put this procedure in place, but right or wrong, I don't understand why we're complicating the whole procedure and open ourselves up to subjectivity of whether the question is right or wrong, that type of thing. I don't really see the relevance of why we're doing that, but I'm not.
But what else would you recommend to test on the technical knowledge?
The same way, you just do a written test. You're going to develop a set of questions either way.
I will say, many of the issues I think the board is discussing are what led to that initial recommendation that the board rely on the experience of the applicants to determine which fields that they could apply in, and then go to the less subjective testing requirement with the questions that we already have that have been verified through that process, which obviously present less risk going forward, and provide the most streamlined process to get this going as quickly as possible. I understand the board's discomfort, I suppose, with that, but that was the thought process that went in, is, all of these questions about, well, you have question development and the subjectivity and all of those things that are being discussed that are, I think, somewhat complicated in how to move forward on this issue.
So is it your recommendation not to have the oral interview?
It was our recommendation at the outset it is your discretion whether or not to have the oral examination. You have the authority to do so.
I don't think the board is going to vote to have a test only on
laws and rules.
and that's, I get that feel from everybody up here. There has to be a technical portion on that test, either written or oral, before they're willing to grant a qualifying agent license to a person. Just to come in and test on laws and statutes and rules is not acceptable. And I think we were trying to find the least obtrusive way to get that technical knowledge in there to show the person's qualification in order to streamline this process. But my feeling is the board is not going to approve just on the 32 laws and bylaws.
Right, I understand
Yeah,
that, and,
okay.
and I think in that instance that I mean, if you're looking at your other options going forward, I think the subsequent or concurrent oral examination may be the most expedient way to deal with that, if that's a 20-minute oral examination with the duty to, to develop those questions. The question arises is how those questions are developed. There are copyright and legal issues with using questions that were developed by another company that we may run into. You can't. And so the question becomes, well, where do you get those questions from, or do you do it, the oral examination is, that determination with a write-up where the board member makes a determination at the end, pass or fail, that this person...
Again, if that oral interviewer documents how they reached their decision, I think it's going to be defendable in court. They've got to document this, they touched on this key element, whatever, in those questions, and there will be common key elements that the person should know if they have the knowledge for that license, and then that becomes a part of that person's test file. I think it's defendable in court. But, like you say, you're limited it to 20 minutes, so they're going to have to keep everybody on track, but yet cover the issues, which I'm not a alarm person, I'm the public member, that they know that the person in fire or burger, whatever, they should know these answers, A, B, C, 1, 2, 3. And I have full confidence in these people to score them legitimately and not pay favoritism, say, well, they kind of knew. I don't think that's going to happen, because otherwise they would not be insisting on a technical portion on that test. And I agree with them. There should not be a license granted for a qualifying agent without that person proving they know the technical part of the industry. I wouldn't want a fire alarm installed in my house by somebody that wasn't qualified to do it and, subject my family to burning up. And I think that's the concern that all the rest of them have as well.
Right, and all I was saying on the oral portion of that exam, that I believe Ms. Vest and her staff would need some guidance as to what those areas
I think it would be, I think you should reach out to the licensed board members and then let it be a consensus among them that, yes, we're going to do these 4 or whatever, 3, whatever, 5 they agree to in a number, and everybody agrees these are the questions we're going to ask in each category, and then go forward. And that should not take too very long if everybody would submit questions in the area that they're most adversed in. It could be bird for Ms. Jones, could be fire or CCTV, and reach out and let each one of them submit the questions, and that can all be done by email.
Well, and the discussions of whether or not what to do with those questions couldn't be done by email. I agree that each individual board member could submit what they think those questions are to Ms. Vest, but then she can't redistribute those and facilitate that discussion, because that would be an open meeting issue. And if what you're suggesting is that each board member submit questions for their relevant field, and then you delegate to Ms. Vest and Ms. Smith-Bell the task of collating those into an oral examination, again, that each member is individually providing those, and then she's handling the task of...
I agree. I mean, you're getting it from industry experts, and then, the questions should all be reasonable and fair, then y'all pick what you want out of it. I don't have a problem with that. I just want it to be fast and efficient without inconveniencing these folks to have to come up here another day and miss work or whatever. I would have it like in bullet form, that this is what the answers, in bullet, yeah.
Yeah, I mean, the answers in this, if I understand you correctly, would be determined by each, if they sufficiently answered that question, that each board member should have sufficient knowledge to make that determination.
I think a form.
Right.
For each exam with the same sign off on it, and the applicant to sign off on it, and we can do all that once you,
Right, but I mean, that form can have the interviewer's notes written on it to where it's very streamlined and it goes in the file and you've got everything from that oral interview right there together. And everybody's is the same in that particular category. Yeah. To just approve the temporary process. Okay. Do we need to repeat the motion, or are we all clear on what we're going to do? A temporary process for the testing procedure until a contract can be signed with a testing company. This temporary procedure allows for a written test to cover the rules, laws, and bylaws, and an oral interview process to cover the technical questions for the classification that each qualifying agent candidate is applying in. Does that pretty much cover it? And to allow the staff to administer, or not administer, but to be the, what word am I trying?
Written portion.
Yeah, they're going to be responsible for the written, but they're going to coordinate all of it from questions received from the board members.
And coordinate when we...
Testing all on the same day, so.
And since we can't, you said we couldn't charge for an examination correctly, it would seem only fair that the applicants that are coming down to take, yeah, probably not, never mind.
I have a motion for this temporary testing procedure. All in favor? We need a second. We have a motion by Mr. Roberts. We have a second by Mr. Harvey. All in favor, voice by saying aye. Aye. All opposed? Motion carries. Are all minds clear and happy?
And we'll have to get our heads together and work out some of the details, I would think, but now we have a process in place that would allow people to, or basically a testing process that would allow us to appropriately issue qualifying agent licenses. And I think we need to move forward with this in a very expeditious fashion. I would think that the written questions could be prepared in a couple of weeks. I think, yeah, I'm not trying to put you in a box there on that, but what I'm thinking is that, or my thinking is along the lines that we should probably within a couple of weeks be in a position to start scheduling these examinations. You'd want to schedule as many as you could on the same day, just so that it's done in
Make
some...
sure the board members are available too, that where it doesn't inconvenience the board members or y'all. And I think, I'm sure that can be done to where you've got your board members here that day to expedite the procedure. And break them up in categories. If you got 3 or 4 board members, then I think you can get the people through there a lot quicker and not be too long.
Something, and I hate to belabor the point, but
Okay.
I think would be useful is if we could get a vote from the board, if the board is comfortable doing it, on the number of questions, if you want all 32 questions and a passing percentage on the written exam, and then the number of questions you'd like to address. And I think 20 minutes was mentioned, but the length of the oral exam.
That's a good point. I'll make a motion that the written portion of the exam on the statute, rules, and regulations consist of no less than 25 questions with a 70% pass rate in order to pass that examination.
If they pass the written, then they pass the test. They don't need the
No,
oral.
if they've passed the written, then they've passed the written. But that would establish the pass-fail rate for the written portion of the exam and the number of questions, which was something that was recommended to us.
Okay, so this applies only to the written portion of the test.
Only to the written portion of the question.
A minimum
test.
of 25 questions.
Minimum of 25 questions with a 70% pass rate.
To move forward to the oral.
In order to consider that portion of the examination passed.
I think they've got the motion on the...
No, we got a motion on the written part right now.
That's as far as it goes right at this point.
Okay, we have a motion by Mr. Roberts for pertaining only to the written portion of the exam, that it will consist of no less than 25 questions, and the applicant must have a 70% or better score to pass. Do we have a second?
Forward to the
To
oral?
to move forward to the oral.
So that way, if they don't pass the written, then we don't have to fool with the oral.
If you're doing it the same day, I doubt that there would be time to do the scoring in between there.
If you do a written test and have those little punch cards, things like that, that should be pretty quick. But I mean, I'm just, whatever y'all want to do is okay. Okay.
For now, so.
No, I understand, but you've got, where they can mark A, B, C, or D, you punch the holes out, you can score one in about 30 seconds. And then yes or no.
And then they wouldn't have to move forward to the oral exam. Cut down on the time that the board members would have to spend with them.
Well, I think Ms. Vest and her staff would try their best to score them as quickly as possible. I would advise against binding to the procedure where they're required to score them before the oral portion of the exam.
Okay, we have a motion and a second on the written portion. All in favor, voice by saying aye. Aye. All opposed? Mr. Harvey.
On the oral portion, and again, I'm just trying to throw some things out here. You'll do what you decide to do. If it's a 20-minute exam, if what you want Ms. Vest to do is just collate all of the questions given for each area, and the board members be given the entire list of questions that are...
And then which questions were asked would be at the discretion of the board member. The board member is going to have to evaluate the quality of the answer, since it's an oral interview exam. There's going to be a lot of subjectivity here, and I don't see any way to avoid that, quite honestly. If we've got questions in a particular subject area that would be helpful guides for the examiner to be using, I think that would be very highly desirable. I would not want to see an examiner limited to a particular list of questions. I think they would be a valuable guide, but there's just going to be a lot of subjectivity in any sort of oral examination that you give them.
Document the score.
I think the examiner, whoever that might be, first of all, I feel like it should be a board member qualified in the area that's being tested. And I think that the examiner should either give a pass-fail rate and probably some sort of a narrative, a brief narrative as to why they, in their opinion, the person was qualified or not qualified. Now, I guess we need to put... Madam Chairman, I make a motion that the oral portion of the examination that we've discussed for the qualified agent be, first of all, administered by a board member qualified in the area being tested, that if possible, a series of questions available as a guide to that examiner be made available, that the examiner then determine either a pass or fail of the examination, and that the examiner provide as a part of the evaluation a brief narrative as to why the examiner felt that the applicant was either qualified or unqualified.
Okay. We have a motion by Mr. Roberts on the oral portion of the exam. Beth, did you get all of this? Okay. Do we have a second? Have a second on this? Okay. Pause for lack of a second. What do we need to reword it to?
They're going to do the, okay, so if, there's only a yes or no answer, a right or wrong answer. Ask them what gauge wire to run, they say 22.2, that's right. If they come up with 18.4, that's wrong. And why would we have to discuss that with them? I mean, I don't understand why we'd have to
I don't
be
think
in
we-
a room to discuss it with them. If we come up with the questions in that certain category, like we did with Prometric, we went over the questions. Why can't we just administer a certain set of questions to each applicant that's applying in that field? I don't,
Got to do that. I don't think you could just, it's too much subjectivity to it. I think you're creating a huge problem for ourselves. And whether it's oral or written or whatever, I think it's set of questions. That each person has the same questions and right or wrong.
So
Why do we have to be?
But if we change Mr. Roberts' motion to reflect a set of questions relative to each classification, not the guide, but these questions are the ones that will be asked for fire, these for bird, then that would be acceptable to you if every candidate was asked the exact same questions.
right.
Okay?
If a candidate sits before Mr. Roberts and they discuss a few things and he decides that he's not relative in his field and he shouldn't have a license, then he reapplies and he gets Mr. Harvey the next time for the oral questions, and Keith decides with the questions that he asked him, then he was knowledgeable in his field, so he passes. I think the candidates are going to be able to, they're just going to point a finger, that board member, whatever, caused me not to get my license. But if we had a set amount of questions, they couldn't say so-and-so.
Well, my concern is that when we worked with Prometric, we worked for about 4 months to develop the questions and the examination answers, and we had to validate all of that. And I'm concerned that that process would just take too long to be effective
Well,
in
do y'all
this
still have the
process.
questions that you submitted for Prometric?
No, they belong to
They
Prometric.
own them.
I know, not the Prometric questions, but the questions that the board members recommended. They wouldn't own those, would they?
Are we not having to come up with the questions anyway? That's my question.
That's what I said, we're going to have to come up with them.
I selected a reference book. You're going to have to tell the
But I remember going over
you
questions.
select a reference book for each classification and take the questions from
Problem.
Well, again, there's sample test questions in the back of the books, right?
At the end of each
It's
chapter,
copyrighted
there's
material.
The problem is we're going to have to be able to tell our applicants what they're supposed to study or know.
Well, they're not going to have time to, when they come before the board, they either know it or they don't.
Right.
Well, I mean, if I only had to memorize 32
Maybe
questions
say,
out of
we're
that
going
red
to use
book, I'm going to
questions out of this
pass every
reference
day,
book for this
all the time.
oral exam or something.
We at this point, we've established a procedure for a written and oral exam. At this point, we've also established a procedure for a written portion of the exam. Now, what we need to determine is what is going to constitute the oral exam.
Correct.
And that's remain.
That's correct. It's just that each board member would submit their questions to us. Of course, we're going to have a pool in case they did not pass it and have to come back and ask. Would administer this exam to them. Instead of oral, it'd be written, but it'd be 4 questions. Is that the direction I was?
Well, that's kind of it, but I think what Keith was hanging up on was when Mr. Roberts said, have a series of questions that would be used only as a guideline for the interviewer. I think what he's wanting is the consistent same questions ask to each applicant in that classification and not have, you're cutting out the subjectivity of the interviewer not to be able to pick and choose the questions. Everybody get the same questions. She used the example a while ago. What gauge of wire would you use to run this? They either know it or they don't. You know, and then...
Well, to that point, exactly. He may use 22.
I don't know if you'd run a 40 gauge wire. I was just using
There should be a proper guide, but, you know, industry standards, both may be acceptable. I think we need an answer and a question and answer. Instead of...
Those two people could answer two different ways and it'd still be right because you've got a conversation going on.
But if they say 18 and they explain why they put 18, that would not be wrong. I mean,
Sometimes it's recommended but not
Maybe
required.
that's not a good test question to use. Let's try it.
Let's just forget
I'm
that.
just saying, you'll get into that. Sometimes things are recommended but not required. And so they'll get by with whichever answer they put down.
I'm not hung up on whether it's written or oral. I don't really care about that.
We've established a process for a combination of written and oral exam. We've established a process for developing a written portion of the exam on the rules.
Questions and the percentage. We've got that part taken care
Now
of.
we've got to work out the details on the oral examination. How do you want to do that?
Just saying that either way that we do it, we've got to come up with the questions and the answer.
My concern there is, again, I said it before, and I hate to keep repeating myself, but I know when we worked with Prometric, we didn't even do it all. Prometric did the bulk of it. We just went through an evaluation process and validation process of the questions that they developed. That took months. And I'm unwilling to see, that process be repeated, and then when we get a testing agency, repeat it yet again. I just think that is not an acceptable time frame. I just see that it would take too much time to go through and develop a long list of questions and answers and validate them back against the codes, and I just don't see that as being a process that is suitably expedient.
I agree with that. But at the same time, we've got to come up with the question.
Why can't we take the study guides that were already in place, take questions? We don't have to use their questions that they have printed in the book, but we can find questions and answers in those books pertaining to that category, submit them, and there we have our exam. Yes, because most people have already purchased them.
The same Mike Holt book, and all of them had the NTC book.
Right. Right. Most all these people have already purchased those books, or have studied them, or use them in the field, especially the NFPA. But why can't we just take the questions out of those books?
Take the questions from those.
Yeah, from those books, because most of them's already been studied. And don't find a question that's iffy. Find a yes or no question, and submit it.
Well, and
No, not their questions.
Saying
what
take,
they're
she
saying
said
is
just the question.
right.
Just look through their book and find.
But use the reference material that
Use the
everybody
same old
pretty much
reference
has in
material
the
that everybody
industry.
has. And
That's
just,
telling what I was suggesting, is to list a reference book and use that book for
That's
your
okay.
oral exam questions, just so
Yeah.
you can identify to the applicant what he might need to review before he comes
But
in.
my thinking on this, because we are trying to speed this up to get these people licensed and through this process, I agree, in the real world, the perfect world, the written test to cover all the technical would be the best thing, and that's what we're saying we're going to go back to. But I have full faith in these people that if somebody comes before you, Keith, and you've got a series of questions, and they answer those questions, you're going to know they know what they're talking about, or they're just dancing around. I think your gut feeling is going to know they really are qualified for this license, and you're going to sign your name down there that they are. But
Fail somebody on a gut feeling.
I'm not saying you're going to fail them on a gut feeling. If they come in here and they start talking black and white when everything should be in colors, you're going to know they don't have a clue what they're talking about. But you're going to be able to determine, exclude gut feeling, you're going to be able to determine from talking to them, when you do interviews for employees, you know if they know what they're talking about or if they're just coming in there shooting the air.
yeah, if they say they're going to hook the key bus up to the siren, you know they don't know what they're doing.
Y'all know key things that you're going to ask them, and if they don't answer right, then you don't do it. But if you have you know from your experience, yes, they know what they're talking about, they've adequately answered, then you're going to approve it. But it's to speed up the process, because like Mr. Roberts said, it takes these testing companies months to formulate written questions. Then we go back to square one. Nobody's going to vote for just the written test to give a qualifying agent license. So we've got to have some process to get this traffic
We're going to have to
jam
make some
moving
questions whether we
along.
want to
Wait
or
a minute,
not.
y'all have already voted on the oral exam, and the motion carried.
That's just for
That was just to say there'll be an oral exam or oral interview in this temporary testing procedure. Now he's wanting us to kind of, firm it down on what we're expecting.
I wasn't expecting this today, period.
No, I was
I didn't know it
neither.
was on the agenda, so I didn't come with any ideas.
I think we need to press on with something, because if we're not going to have another board meeting for 2 months, to leave this question in abeyance and to leave the companies that need a qualifying agents for their properly licensed operation, and to protect the citizens out there that need benefit of the alarm systems that would be installed under their supervision. I think we need to press on with this.
Well, I think, once you ask these people a series of questions and they answer it satisfactorily to your knowledge, and ask them. But if you have any doubt that they don't know what they're doing or what they're talking about, you would not pass them. And they can come back and try to get once and done, but for that particular time, they've got that opportunity. If they fail, then come back again.
Okay, if we do it that way, where are we?
They just said they would use the reference books and just take questions from the material covered in the reference books and say test questions will come from these reference books.
Well, that brings up another question. Will they be allowed to bring those reference books in with them like they did with Prometric, or will it just, if you ask them a question, can they say, hang on a minute, let me check? Or do they just answer the question and go on?
That's up to you guys.
I mean, because then, in the Prometric situation, if you didn't know an answer, you could sit there for 30 minutes flipping through the book trying to find it. But then that's going to pass our 20-minute thing.
I would hate to think
We
somebody
haven't
would have
agreed
to
on a
book
20,
in.
we haven't agreed
Well,
on a
that's
20-minute thing,
agreed.
but
That's
Right,
just
but I'm
gonna
just
be another
saying, that's
thing
going to
around.
knock it in the head. And would they, if we take the questions out of the reference manuals, would they be able to bring them in with them when they have the oral exam?
I say no. This open book thing to me, just you either know it or you don't. You either deserve it or you don't.
Are we okay with doing an oral like we're talking about, or are we creating problems?
we've already established by vote that we're going to have an oral exam. What we're discussing now is
Trying to find out where to get
the
the
form
questions.
that oral exam should take and how we should go about it.
And I will note, and I think that has been noted before, there is some risk of challenge going with the oral exam. Of course, there's some risk of challenge because the questions weren't developed through the metrics process that are traditionally used by the testing vendors to giving it as a written exam too. And I mean, those things are real, I don't want to say threats, but they're real things that could happen. I mean, certainly that's a possibility in either case. And, it's been discussed, the problem with subjectivity in the oral exam. And so, yes, that is a potential problem. But on the other hand, I've taken a lot of exams that are essay exam style questions, and so I think there is a way that you can justify the use of these type of questions, but of course there is the risk of challenge that someone says, well,
Okay, let me ask you this. What would be the possibility that you rig the room up with a video camera and you have these interviews recorded, and if they're challenged, there's your proof right there.
I'd have to confirm on our capabilities of doing that, honestly.
I know that, but I'm just saying, that pretty much eliminates any right or wrongdoing on either party, and the documentation that the person puts down there at the bottom, the board member says, I vote they do get, or I say they do get their license based on this. You've got a video camera right there. If it's ever challenged, right there you are. You've got, and it's going to hold everybody to a standard of being consistent.
Let a different board member, if so be it, review that and say, well, they could have been, they were out of line or they weren't.
What happens if they are
I'm
on
saying
four
only-
classifications? They're going to get four different boards.
That's possible.
Yeah, but I
How
mean,
are going to get through a day?
Yeah.
if you've got that many, that's why I said if you do, I just threw out the number 20 minutes, because if you've got the 4 board members here running interviews at the same time, then, you're only talking between 3 and 4 hours to get everybody in and out. But, I mean, that's going to be up to y'all as far as scheduling and how long you're going to allow for the written exam out of an 8-hour day.
And incidentally, I think 20 minutes is probably a
I agree,
reasonable time
because
frame.
that's about what you normally have for
That's
me.
not unrealistic.
Most all of us could do the Berg. I would feel more comfortable if Ken did a fire interview instead of me, even though I've had extensive classes. I've not had extensive installs like he has. And then, maybe Keith, yeah, I'm just
Absolutely.
saying.
I mean, that can be decided, whoever
But we've all got Berg is what I'm saying.
Right.
But even though I have fire, I would feel that he would be more competent.
But as far as what Mr. Driver was saying about the challenges and all that, if they want to challenge it, let them challenge it. Take it to court. Here's the video. And that pretty much says it all. There's no subjectivity in that video about what the person did or didn't say and how the board member conducted themselves. And you've got professionalism on both sides. Let it be known you're being recorded, and let it go.
Yes. Yes, that's correct.
But what was that anything to do with the alarm industry or the engineering?
No, it was an engineering examination. I was just using that as an example of the process.
What would that be out of the question?
What I envision is something a little more simple. You'll recall that in times past, for instance, that we've had board members that would interview when we had a case that would be brought up, that we would have a board member that would interview, in some instances, that particular case, review the circumstances, and make a recommendation accordingly that was then transmitted to the board. I envision some sort of a process like that, although I think in this case, I don't want to have a board meeting to grant each one of these QA licenses. But basically, I envisioned a process like that, where the person being interviewed, and I'm calling it an oral examination because our statute requires an examination rather than calling it an interview. But I really envisioned more of an interview process. You had suggested questions. If we had some questions that could be used as a guide, that makes kind of sense. I don't have a problem with it, but I think it'd be questions. I envisioned it as questions that might be asked during an interview process. You might want to ask 2 or 3 of them. You might want to ask 4 or 5 of them. You might want to ask some questions that just appeared appropriate at the time. But I really envisioned it more as an interview process than a technical examination per se. But I think we're going to have to do something to move forward with this, and I think to establish a long list of questions is just going to be too time-consuming based on what we've done.
Well, I don't see needing no more than 5 questions, because that's 4. Most people are not going to be,
5 questions.
5 times 4 is 20.
Frankly, I would have a high confidence level in each of you as board members to ask questions that were appropriate and to exercise good judgment in the evaluation part of a person being interviewed and examined.
You wouldn't have the same questions.
Not necessarily.
I think you're going to have the same 4 questions. Ask a
Again,
follow-up question
I think
that's permissible.
I think we could have some questions to be used as a guide.
Several test questions, all listed on your form, and you select 5. You could check off the ones you actually asked, and you wouldn't have to ask this. You don't have to fill out a form anyway, so we'll just make the form comprehensive where you can note the questions you ask him and the responses, and then
Really, you're going to have to, because you're going to have some type of statement or justification beside each one of those questions to justify the pass or fail. And it would make it a lot easier to do it individually.
But again, if you had several to choose from, you wouldn't necessarily have to ask the same one every time.
I think part of this, if I may be part of the conceptualization of what the questions are, and I think some of the board members are thinking about questions that have a very direct answer, like what gauge of wire, and you'll forgive me, I know
That's just a
little
good
to not
question
think about
for us lay people to use.
the installation of alarm systems, but as opposed to, I think some of the other board members are conceptualizing something, again, more akin to an essay question, where you ask them a question and then they expound on it for 3 or 4 minutes, which I think may be where the 4 or 5 question came from, where you say, okay, you're confronted with this problem when you're installing an alarm on this type of property, this type of alarm. How would you confront that problem? And then you judge their answer based on that, as opposed to what sort of wiring would you use, or that sort of thing. And I'm not saying, which one is which. I just
You can
think
give them the specifics of the issue and let them tell you, like you say, how, it may
How
be.
they handle it.
Exactly. And you're going to know A, B, C. They know what they're talking about, or they're shooting in the wind. It may be, what type of system would you install in this particular building, and you lay out the type or whatever, just to show that they know what they're talking about. How many sensors, whatever. I'm just using
As an example, if you discussed a fire alarm system, you might ask the question, well, would you recommend that this question be an intelligent system, an addressable system, or a conventional system?
And why?
And let them respond appropriately. You could ask a question such as, where in a building would you install fire alarm pull stations? And depending on how they answered that particular question, I think you determined pretty quickly whether they knew what they were talking about or not.
Absolutely.
How high up the wall could it be, and how high can it not be?
You're not going to build the clock. You want them to be able to show they know how to tell time. And that's
So,
how I
that,
look at it.
and to me, that, and there's subjectivity involved in that. I don't see how you're going to avoid that unless you do go through a complete, list and make up a list of questions and answers and go through the metrics evaluation process we've been through before. And I just don't see that feasible in the time frame that's reasonable.
I know, but we're asking, we're not trying to overwork y'all. We're trying to find something that's
Helping or hurting?
helping or hurting or is
However y'all do it, we'll just have to stop what we're doing and do it, so.
Well, we just
That's
want
just
y'all to
the
just
deal.
take out one day, so
Well, we need to make some
one whole
sort,
day and be done with it.
we need to make some sort of decision
I
on how
agree.
we want to deal with the oral examination / interview process.
Okay.
What do you think?
Or do you
I
want to make
think-
the motion?
I think we're getting there. At the onset of all this, the whole discussion began around needing a technical portion of the exam, and how maybe we are getting enough technical portion in an essay interview.
I think you can tell a whole lot more about a test taker's ability and not to them versus them marking a true and false or multiple choice answer on a test. Versus a 50% yes or no on a true and false. I'm sorry.
Does anybody else have any of the reference manuals? I'm sure everybody's got the NFPA 72 book, but does anybody else have any of the reference manuals for any of the other classes? I've got 4, 5, 6 of them maybe. But is there a day that the 4 board members that have QA licenses could come down here, get together, sit down in a room, out, let's say 10 questions in each category, and make us a guideline. And then when the applicant comes in, we don't have to ask all 10 of those questions to that person. We could ask the first question and evaluate how much they know, and then we could go down through some of the rest of the questions and figure out which other question we need to ask to see if they know enough. So maybe you don't ask all 10 questions in the same category, but you check what they knew and what they didn't know and put why. But is there a day that we could all come down and get together and just at least come up with 40 questions out of those reference books that they had already asked us to study? Because those individuals have probably already looked at them and studied them.
I think what you're suggesting is kind of what I had in mind.
Oh, I said it different.
Technically, your question was, is there a date? And I would say we could pick out a date.
Yeah, soon that we could do that.
Yeah, but then you're going back to what he's getting caught up on is having a guideline of questions instead of having 5 questions verbatim. Every candidate gets them. They either answer them right or wrong, move on.
Okay, then let's just pick 5. All right. I was giving them the benefit of the doubt with 10.
But say 5 questions, they either answer them or they don't. There's, everybody gets treated the same. You're not going to jump down and go, well, this question's easier. I think questions, move on. They passed or they failed.
We're going to have Vivian present, so she can.
Thank you. Y'all going to hell will be hating me.
She's going to have a big watch on her hand going,
Go! You do have to have a timer, no joke. You have to have a timekeeper. I'll come up and do the I'll come up and run timekeepers and all that stuff, but I'm not going to be qualified to ask the questions. I'll do running around. I'll even score your tests for you. Seriously.
there, we got that
If you
covered.
want to lay that out in a motion, and you guys feel confident that we can.
Sorry that I just expounded on it.
I'm not sure I understand what you wanted. No.
It died for lack of a second, so we started back to ground one.
I'm not sure I'm clear on what you feel or the
Can I make a
process. Yeah, as far as I'm concerned, you can.
Okay. My motion is that for the procedure for the video portion of the exam to show, for the oral portion of the exam to show technical knowledge in the area of classification, that there will be 5 questions asked to each applicant, again, in the area that they're testing for. It'll be the same 5 questions. A board member will administer these questions and will determine that person either passes or fails the oral interview. They'll be videotaped and they'll be timed. And there'll be documentation submitted on a form, question form, by the board member as to why they passed or failed that person.
And will they have to wait so long before they retest if they protest this?
We've already covered that in the other part. If they fail, they come back on the next test.
I have a problem with that.
All right.
First of all, I could not conceive of any 5 questions that would determine the technical ability of someone in the fire alarm industry. There's no 5 questions that I could ever imagine that would determine someone's reasonable qualification in that. Secondly, if we're asking everybody the same 5 questions, the first person doesn't pass the test, he's got the 5 questions, can tell the next guy what the 5 questions
No,
were. But you see what I'm saying?
You're going to segregate these people. When they go out the door, they're not going to be, if you test them the same day.
I'm not going to get everybody tested the same day.
What about the folks that take the second round of examinations? They're going to have the same 5 questions? I just can't conceive that there would be any 5 questions that could be asked. And that's a problem. I agree the objectivity there would be, is nice, but I just don't see that's a feasible way to approach it.
That just means we're going to have to come up with more questions in our little get-together then.
They have to determine exactly how many questions right now, or can they say for 20 minutes conducted by a board?
Yeah, I think it would be better if we knew the number of questions. I understand that you may not have that information available, and if that's what we have today, then at least having that on the table with the board to determine.
What about on that particular test date, everybody has the same 5 questions? And then if you have a second test date, they're given a different set of questions if they're retested.
But it's still, I hate to object to what somebody else is suggesting, but again, I just cannot conceive of any 5 questions that you could ask a candidate to give a yes, no, or arithmetic answer of some sort if that were the type of questions.
I used the yes-no example on a written exam. I think the feel for what you're going to gather from that person when you ask them this question, because you're not going to have a yes-no answer to it. They're going to have to tell you, this is what I would do and why.
Well, see, that brings the subjectivity back into it, and I think that's the way we're going to have to go. It's not ideal. I would like to have where you're grading everybody exactly the same. Everybody has the same questions.
Let's say if it's acceptable by the industry, so their answer, let's go back to that silly gauge wire, if they can explain why they're using 18 gauge wire in this versus 20 gauge wire, then okay, that's right. In your mind, you're going to make that determination as a subject matter expert. Yes, 18 gauge wire would be okay to use here. But if they say I'm going to use 40 gauge wire, red flags should go, hey, they don't know what they're talking about. If they can justify their answer, then okay, but you're going to have to justify, and that videotape is going to say, yes, they did, here's, what they did.
And the other thing I might recommend, if you can, on the videotaping portion, if you're going to go forward with that, if you can make that a recommendation, because we're not sure about our ability to accommodate that, and I certainly think Ms. Vest and her staff would do their best to accommodate it, but I don't want them to not be
I
able
only
to
said
comply.
that for the protection of the state and the staff members, and I know they probably have, but I did that for the protection of the parties involved, that if it was to be challenged in court, you've got something to show the words coming out of that person's mouth themselves versus a rendition from another person.
Right, and that,
Well,
and
they said this, no, this is what, that would be, that's done in a lot of assessment centers these days.
Or that we had an attitude toward
Exactly, or you weren't treated like I was.
but if you made it a recommendation, we could go forward even if it's not possible. If it turns out the logistics are not possible to do,
I'm not
and that has
comfortable with
been...
it not being recorded, I'll just be honest with you.
Okay.
I'm not comfortable with it. Because I want protection for these folks, that they were not sarcastic or didn't ask them the question fairly.
Interesting. I hadn't thought about that.
Thank you. Thank you.
Well, again, taking that as a recommendation, that interviews / oral exam be video possible. It makes sense.
But we don't...
They're all over the United States, so I don't see them all coming in the same day, so.
I know, but, if they want, we're doing everything we can, taking 2-3 hours to make it possible for them to do it. And I'm not saying give them 7 days' notice to be here, because it's going to take a while to get this all put together. But, okay, we're going to give this test this date. We're not going to give it this day and this day. And if they want it bad enough, short of death.
Once we get it all firmed up, and then we send them a notice, and they'll have to register, so we'll know who's coming.
Exactly.
But we can't do any of that till we get past this, so.
I understand that, but I'm just saying, we're doing this to accommodate them, not to overwork y'all. And, you may want to do the background checks or whatever you want to do first to even see if they can move forward. I just want it easy for y'all.
I understand that taking the laws and rules questions and giving it to them and saying, all right, take off, you can work now. But that's just dumbing down our industry. If you don't give them some technical questions and have somebody that knows what we're talking about do the interview.
Well, that's why we included that in the original
It
motion.
just feels like
that.
It just feels like our industry has been kicked to the side if you're just going to do it that way.
I think we already passed that point.
We're ready.
Yeah.
We're just trying to pin
We're
down the
just
oral
trying to
interview
determine
process.
how-
Last thing we got is what Vivian said. She said,
Questions was thrown out.
I think we started with 5 questions, and then we rolled around to maybe we should have a list of 10 questions. 5 on each, or have y'all even made a decision on that yet?
I don't have, if they want to submit 10 questions, but on that particular day, everybody that tests on Tuesday, the 4th of August, needs the same 5 questions, because you're showing consistency. Now, if the group that comes in on September the 25th, they may get 5 different questions, so they need to submit 5 questions. Let me change 10 questions. But you want to show that whoever tested that day, they got consistency. And if it's a retest, then that's okay.
We're going to schedule a really brief.
Reference books that they're going to bring their reference books and take the questions, not the questions from the book, but make questions from the
Make
material
questions out of the
covered
material.
in those books. That'll be their reference for the questions, but not the actual questions from the book.
And surely we can come up with some yes or no questions out of that book instead of, well, you could do this. Any of the books.
Again, I cannot conceive of any 5 or 10 questions that would be yes or no answers that are
No,
that
you don't
would
want
be
a yes or
adequate.
no question. Otherwise, we'd write it down and let them check yes or no.
Let's just make all kinds of questions and have the sheet. Let's say we got a sheet of 50 questions on category. And you just get to pick randomly
No,
what questions
we're
you
not going to
ask.
write 50 questions. You going to write 55 questions?
Don't bother me.
No.
Be better than my youngin' burning up in daycare.
I'm not married to the 5 questions. If y'all would feel more comfortable with 8 questions or 10 questions, but what I want to do is to be able to give this person an adequate amount of time to explain what they would do, not just with a yes or no, true or false type thing. And if you're going to limit them to 20 minutes, which is reasonable, you can't ask too many questions because you're not going to give them adequate time to show they have that knowledge.
Are we married to Prometric, and why can't we find someone else to proctor the exam?
There is no contract with Prometric. There's no contract.
I know. We're done with him, but I'm just saying.
Prometric doesn't even play into it.
We don't
except
have to
they've
wait
got
on them.
They've got the 32 questions.
Is there no other kind?
No, there is no.
Who does
no.
the testing for all these other regulatory boards in the building?
Irrelevant. But it's irrelevant because we don't have a contract with them, and PSI has the
PSI.
others.
Could PSI not do ours?
I'm Charles Snyder, liaison with the department, and the question was who does the other testing for the department. There's a company called PSI. That is the company that we're currently, we've been in negotiations with for this and a few other license exams, and are trying to get that done. Their main attorney that has been negotiating the contract is out of the country at the moment, and we are trying to expedite that. They have a junior associate that's sort of working on that, but Ms. Vest is right. Even if we were to get that contract done next week, it's going to take a substantial amount of time, and the burden of, qualified people who have everything together, ready to go, but the test is not available, they're going to continue to be stalled and prevented from coming in. And for companies that may lose a qualified agent, they're not going to be able to test someone and get them in to be the designated qualified agent. That's the exposure the board has right now, and I think that's why Michael has suggested the things that he did. I think which y'all are talking about makes a lot of sense. A limited oral exam is not dissimilar to what other boards do. The contractors board here, it is not a requirement of everyone, but they do it's not a formal exam, but it is a substantial interview process for anyone that they have questions about. And obviously, the requirements for someone to be this license that we're talking about, I mean, they have substantial experience in the field, and your oral exam provides you with, eyes on this person does have that substantial experience, that this person does have substantial knowledge in the field for whatever the designation they're applying for. And, with you as members of the industry putting your eyes on them and speaking to them, you're going to have a very clear understanding on someone that comes in. If I was to come in and present you with documentation that I have 5 years experience, I'm not going to know what I'm talking about in the industry, and you're going to say that person is not qualified for this position, and therefore you deem them to have failed the oral exam and should not be licensed at this time. Because you'll have the video recording of it, if they were to challenge, you're going to be in good stead. But someone who does have substantial industry experience is going to be able to come in and speak to you as a colleague and someone who knows and understands the industry, and you are going, whatever the questions are, you are going to say this person is qualified and is acceptable and is someone that will maintain the professionalism of our industry that we have worked so hard to maintain. So, just with that, I mean, I wish PSI could step in tomorrow and turn the keys on, but the reality of the situation is, with our previous vendor walking away, we just are stuck in a very awkward position, and it sounds like the board does want to address this issue, and however y'all decide here, I think a limited oral exam is going to provide you with a great deal of assurance that the people coming in, nothing to say that y'all don't to speak to those people in the future to make sure that everything is good, in the industry. Adam, do you have anything else? Any other sort of specific directed questions?
Oh, I just wondered why we couldn't find someone else.
I think that we're working really hard. I think the board staff did put out for this and other licenses for other boards an RFP, and quite honestly, nobody wanted to bid on them. And so we have done a negotiated contract with PSI to get here, and they're because they haven't tested for us before, they are sort of starting over and starting from scratch. So,
Thank you.
Let me ask another question, and see what you as board members think about this. What if the only way I see to proceed with this thing is a relatively subjective examination? What if there were two board members involved in the interview examination, where they would agree to either pass or not pass the particular applicant? If we did that, then that would if you've got two board members involved, then the videotaping would be less essential or less important. Well, we could do that if it's available, but that would tend to, induce any sort of allegations of bias or something like that. What would you think of that? To slow down the process, because you'd have to have two board members for each exam or interview, and I think, like I said, 20-minute time frame for an exam, oral interview or exam.
You're talking 6 hours of interviews if you double your board members up, which is still within reason for providing, you give them an hour to take a 32-question exam? Is that reasonable to give them an hour, which, I'm just thinking back, that's usually about right. But then,
Prometric just give you 2 hours for 100 questions.
Yeah, but what I'm saying is, would that make a subjective
I'm shooting at
type
the
of...
34. I'm looking at the whole big picture to get the large end of the
some
scale.
of these applicants have
some-
applied in like 3 classifications. Can you handle all 3 classifications in one 20-minute interview?
Let me ask
That's
It'd be difficult.
20 per.
Let me ask this.
Well,
I think we as a board do really well when someone appears before us and we're talking about licensing and that type thing. How much more trouble would it be? Could we speed up the process? Could we take an entire day and the whole board interview each person individually? All kind of had our spiel
There's
down
other
pat.
programs that do that, Mr. Harvey.
I would be
Each
agreeable with
application
that.
is brought before the board, and they have to review it. So we could take, for instance, you could take your exam, your 32 questions, this day. Pass that, now we're going to set you up to come into a designated board meeting just for your exam.
I can live with that, but that's going to require these people from the West Coast to come in 2 times.
What if we schedule it for we offer the exam Tuesday before your September, or we set up Wednesday, the day before your board meeting, just for board interviews and examine.
I mean, we could do it probably even
If
faster
y'all can
than
get that
You- if-
logistically, that's fine.
I mean,
And then you may end up having some other interviews the next day during the board meeting at 2 o'clock. You might have 3 more interviews that we could schedule if you had hearings on Friday. So, again, I don't,
That's up to the board. That's just another suggestion.
any of this can be done.
I'd be agreeable with that.
Yeah, me too.
Yep, I'm-
I'd be real comfortable with that.
All right, Madam Chairman, let me
Make that motion.
let me put this in the form of a motion then, that as the oral exam that we have previously indicated, that oral examination be before at a called board meeting for that particular purpose. and that would allow the board to evaluate each individual applicant based on technical questions that would be asked during the interview with the board.
And the entire board could vote.
And the board quorum would then vote to either accept or deny that particular application.
Okay. Do you have a second?
Second.
Second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Harvey to have these applicants come before the entire board for their oral interview, and the entire board will vote on each applicant, and the time and date will be determined based around the date when the written exam is given.
Rather than say entire board, let's say a quorum of the board.
A quorum of the board, alter that to a quorum of the board. All in favor, voice by saying aye. Aye. All opposed, motion carries.
Sprung on y'all kind of at the last moment, and I appreciate y'all
It needed to be done.
humoring me, and have a great day.
Thank you, Mr.
And let
Wright.
me, before we get off the subject, you don't have another board meeting till September, so we're going to be calling an extra. I'd like to move on if I can get a board meeting set up for the next 2 weeks, or
I think it's exactly what needs,
possible,
as
if that
quickly
is
as
correct.
possible, that's what needs to be done.
not just wait till the first September meeting.
I absolutely agree. It'd be a
Okay.
special board meeting. Let's take another break.
Well, I don't
Oh,
know.
I thought you... Thank you.
We got a lot to do.
Should we call the hotel back?
We're beginning to winter. Yeah, this meeting will be in recess until 1:15. So much for getting out of here on time. Okay, we're going to call to order this Thursday, July the 18th, 2013 meeting of the Tennessee Alarm Systems Contractors Board. Mr. Kilgore, it shows Exhibit B for the next item on the agenda. Are you ready to move, or would you like us to move to something different?
Madam Chair, I'd like to ask, since we do have Exhibit J is application, I would like to move him ahead of the rules in
Okay.
discussion.
Mr. Perry, would you like to come forward? Has he signed in yet? Okay, you will need to sign in.
Would go to Exhibit J. Have Mr. Perry's application. Guess we need to make sure Mr. Perry signed.
Okay.
His employee application. You have included in your packet is DD 214. We do talk to Mr. Perry on the telephone. I felt like maybe if he was could come in to talk to you about. On 4/30/11, it was in Washington, D.C., carrying a pistol without a license, unregistered ammunition, unregistered firearm, which he was found guilty of, and it's classified as a felony. 3106 of possession, which he was found guilty, fugitive charge of a bad check in 2006 that was nully.
2006 was what? No.
No, for two.
Possession?
Oh, the 33106 was possession, guilty, fugitive from justice, dismissed.
Possession of?
Marijuana, I'm sorry.
Thank you. That's okay. And Alliance is located in Nashville. Have a branch in Tennessee somewhere? Okay. Either place is licensed in Tennessee.
Here's one.
Company's not licensed to do business in Tennessee.
Something. The charge in D.C. is not a felony charge. It's a misdemeanor charge. They were trying to charge me with felony possession, but because I did not live in Washington, D.C., and the weapon was in the trunk in a locked box, but still you can't have once you cross those lines, you're wrong.
Why did
either
they
way.
stop you to begin with?
Honestly, profiling. It was locked in the box, so the judge knocked it down to a misdemeanor possession of an unregistered weapon in the District of Columbia.
Are you still on probation?
Oh, ma'am.
So it expired in 2012?
Yes, I completed my probation.
Okay. I wasn't sure. Start or the finishing of it?
Yes, ma'am.
Okay. Theft that wasn't prosecuted, that was involving the dog and the check, was that it? Okay.
Been with Alliance for going on 6 months.
I need some more explanation. Alliance does not have any, they don't have a storefront of any type in the state of Tennessee, correct? They're not licensed as an alarm systems contractor in the state of Tennessee.
I have a Tennessee license, yes, ma'am.
Have a Tennessee license. Okay. Have a regular place of business at a permanent fixed address, so that doesn't mean it has to be in Tennessee for them to be licensed. Okay. So are you the only one that's going to be in Tennessee?
As of right now, yes, ma'am.
Okay. Smiley face.
Companies have a license since like June of last year.
So do they have a license in Texas?
Changed the address from Texas to Rhode Island in March of this year. Initial license was issued, it looks like to me, in June of 2012 with a Texas.
Were you in the industry prior to being employed with this company?
Yes, ma'am. I work for Guardian Protection. I've been registered in Virginia, Maryland, North Carolina, South Carolina.
How long was that?
I've been installing alarms for 10 years. My last was in North Carolina before I moved here.
Motion that we,
Go ahead.
Go ahead. We can't go
Keith,
to
go ahead.
There's an echo in here.
You can show it.
It's kind of go from middle to feet.
I was in stereo there for a second.
Go ahead.
Make a motion that we would accept Mr. Perry's employee registration.
We have a motion and a second to grant Mr. Perry his registered employee application. All in favor, voice by saying aye. Aye. All opposed? Congratulations.
Take a couple of days to finish processing. It will be mailed to Rhode Island. Okay? Sorry.
Not Dallas. Not Dallas. Okay. I don't think anybody else is here, are they?
Copies of the rules, correct? Okay.
Yes.
Well,
Are simply to better the rules that Attorney Simpson had already put in front of you and you had already accepted and approved. They're ready to go. The changes here are just simply to better, I guess, effectuate those changes with regard to employee renewals and registrations. And the changes, if you'll see here on page 2, this whole section about renewal was section, I believe, that had been approved, but we added just a couple of minor changes there about when this is initially implemented. The renewal date for the employees will all begin with the expiration date of the company that they're currently affiliated with, just to give us a starting point, and then from that point forward, it's going to be every 24 months thereafter. Verifying about how to properly submit their renewals and what's required with the renewal, regarding the 2 color photographs, and the language in there saying if a registrant has not met the requirements for renewal of registration by the expiration date of their registration, they shall cease acting as an alarm. Requirements for registration, renewal, and payment of any fees have been met. And then the language about if they have been, and this just mirrors the certification and the licensure language about if they've been in default for a period of 3 months, they're not going to receive a renewal. And over to page number 3, it outlines what arrests and evictions the qualifying agent is required to provide notification to the board of their, and I believe the term registrant is new there, and applicants or qualifying agent conviction. Instead of just encompassing the ones listed in the Alarm Act, I believe we've incorporated any arrest or conviction other than minor traffic violations. Same thing, if you skip down, that was 9I. If you skip down on page 3 to 9, or number 10 there, it just goes more in the contractor and the designated qualifying agent must notify the board of any arrest of the designated qualifying agent or registered employee under their supervision. Defines what a conviction is, meaning the entry of a plea of guilty, pleas of no contest, or a verdict rendered in open court by a judge or jury. Because I believe I had some issues before about what a conviction is, and this better says. Rule number, and I apologize, rule number 9-01-.09, fees. This is something that we just added in the last couple of days because of the examination questions that have come up, and all the other boards have something in their statute or rules saying that the fee shall be paid to the entity administering the test, and this is for when we have a contract back in place. The statute does give the board authority to charge a fee, but as of right now, there's no rule about what that fee is. This would just say when we get a contract in place, all the fees are going to be paid directly to, in the case of if PSI, I guess, gets the contract, it'll be, all fees will be paid to PSI. Moving down, dash 01 dash .10, just amended a few of these parts here to include language about the employee registrant, whereas before it had only been addressing the certificate holder being the company or the qualifying agent license. We've transferred all that language that was already there for both the certification and license holders and added the employee registrant so that it sets out better how the and renewals will work for the employees. Leave everything else in here as far as the door-to-door solicitation and the standards of conduct and ethics have already been before you. And I know that this is something that we really need to get enacted because we don't really have any ethical rules at this point. And I like the language about the contracting with customers where they have to set out clearly what the customers are signing and put it in clear language. So that's all I had on the rulemaking. Eddie, are there any questions? A matter of just cleaning up the rules and putting in the language about the registered employees and making it coincide with all the other existing rules.
Votes on these, as we vote these today, we'll be ready to move on with the,
Have to go through the process, but eventually that's where it's going. I'll accept these, then I think we're ready to go to get a finalized draft into my superiors and go over to up to the assistant commissioner. Approved, then we can set a date for a rulemaking hearing.
already submitted these, and they have reviewed them. I mean, Michael
They've been
Driver, that
reviewed.
was here.
Michael Driver, that was in here earlier,
Yes.
has reviewed these. That change and underline the language about the fee. Final.
I make a motion that we adopt the notice of rulemaking hearing as presented.
We have a motion and a second to adopt the presented notice of rulemaking hearing by Mr. Kilgore. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
They adopt all the policy stuff, not the policy statement when they do the rules. I was looking for, and I was looking in the minutes to see if they already had.
I believe they are.
Mine is Exhibit C. We can go rather quickly through this because we have an open complaints, and we have 4 that is already set up for 4. That's
Well,
right.
settled
One,
and-
yeah, they settled.
One did.
Yeah.
What was? I think the other one is.
I'm so used to my little pointer. Let's go to D, the disciplinary report. Then if you go to E is our normal monthly reports that say the same thing. I have not gotten any verification from the governor's office about his report. If you look through it, it's just your applications and your renewals. These are reports, like I say, we turn in every single month. Doctor, we still got that about Mr. Tucker's being appointed there. And yes, every program that we have but locksmiths has to go through the same process you went through. To be busy.
Perhaps they may just adopt ours. We hope.
It'd be an easier process for some of our other programs,
Ellen or
maybe.
not.
They might not be, they're not as adept as yours. I did that little section there, if you don't have any questions on that. We'll go to our alarm qualifying agent application review. That would be Exhibit F. And we'll take a look at this. I'll give you a little bit of a rundown on that. These charges were, bear in mind, this gentleman here came before the board as a registered employee, and he was approved with the charge in June of 1996. But he's making He was convicted on 85 of possession of marijuana. February, and then in March of 85, possession of narcotics with intent to sell, and received 15 years with 5 years probation. Documentation's included. I'm a registered employee has been approved before you, and coming in for a qualifying agent, we do bring the application back to you.
Madam Chairman, I make a motion that we grant Mr. John Mathis his registration as qualifying agent, assuming he's met the other qualifications, that this, his record here would not present a bar to his receiving his license.
A second.
We have a motion and a second to grant Exhibit F his qualifying agent application. All in favor, voice by saying aye. Aye. All opposed?
And that's, of course, assuming he's met all of the other requirements. You mean the oral exam?
Yes. No, the interview, that's the
Oral interview. Okay, Exhibit G.
Yes, we're going to move on now to the employee application. That is G. The first one is Anthony I believe Chaperone, how you pronounce that. He's It looks like we had in 07 a DUI. He was convicted of a lesser offense. In 04 he had another DUI he was found guilty of. He has some traffic violations in there. 07 was assault and battery. A copy of his current license, but I don't know if I got that on the driver's license, but that's not necessarily a requirement to be a registered employee.
Madam Chairman, since this particular individual is an employee of our company, I feel obligated to refrain from any sort of discussion or voting on this particular individual. Since the first of the year, Ricky Smedley is our DQA for the Knoxville office. Chaperone, Tony Chaperone.
Oh, I'm looking at the wrong one on my sheet. I'm looking at the right one.
A second.
We have a motion and a second. A motion by Mr. Harvey, a second by Ms. Jones to grant Exhibit G his... All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Charges are out of state. These are in Ohio. 504 felony probation violation due to and grant. Follow it through for the criminal record there. 51504 was a felony. Grand theft was dismissed. And November of 01, he had another misdemeanor petty theft for 2 years probation.
Listed on this time, didn't he? He actually listed what he had been convicted of this time.
Probably. I'd make a motion we accept Mr. Clinksdale's employee registration.
H is employee registration. All in favor, voice by saying aye. Aye. All opposed? I vote nay. Motion carries.
Now, this exhibit is somewhat different. How this should be handled in our office. This application came in on June the 5th of 2012.
2012? Okay.
Was arrested shortly after that. Her case is pending. She's gone to court several times.
Are they still pending?
the cases, the court just keeps extending it and extending it for whatever reason, I don't know. Other programs that we have, we will not keep an application open like this. This is the first time, yeah, but she's not on probation. She hasn't been found guilty of anything.
I just have a question, because that's very common for a defense to get a case passed multiple times. And that would be the question I would like answered, is why is this still an ongoing process?
From her attorney, which is on the back of it, kind of explains some of it, but
If not, yeah, huh?
Definition of CDS?
I had to look that up. It's classified as a drug.
What kind of drug is it?
Classified as a narcotic drug.
Oh, narcotic.
so all this is going on in New Jersey. She's a Central
Look at that.
Station employee.
And there was so much of it, I couldn't pick out, well, was it marijuana? Was it cocaine? Was it this? Was it
May have been some of
It
the
was-
bath salts or something
Yeah,
like
odd
that, too.
stuff.
Yeah.
So that's...
Bath salts.
Normally, we would close an application because this would be considered under other statutes we have. Be about the first time that I know of this, for this particular board, so I wanted to
It's a classification for drugs.
read up underneath that, it calls it hash or marijuana.
That's a separate,
Separate charge?
yeah,
Okay,
that's
so-
possession of marijuana
Marijuana
and
and-
some other. It sounds like synthetic or something.
Yeah, so... What if it comes, it's already a year old? She can work, I'm sure.
No,
She's
she's
out of
monitoring.
monitoring, I'm sure.
Very well may, but I wouldn't have it with my vote. Outside of our knowledge of doing it, but I don't,
She's allowed to. She's an applicant in process.
yes, until we take action on the app, and if she continues after that, it's,
Yeah, but see, the problem I have with this, your statute says a conviction. So, I mean,
What if we just find something we feel like is not correct, not good about good moral character? Conviction or no conviction?
looking it up.
I see the letter from her attorney, and it's not that far from now.
Well, no, he says it's going to be dismissed, but I see
I know.
attorney letters every day that says that.
That's what I'm saying, that's
And-
not that far in the future that he couldn't send some type of proof of this action actually taking place, and I don't see sanctioning her in her application today under these circumstances.
farther and farther out, it normally ends up in a dismissal or failure to prosecute. A lot of times. I mean, that doesn't mean that it's going to happen every time, but
Oh, I know, but I mean, if it does, so be it, but we don't have that right now, and I'm just saying, I would dismissed.
That's what I'm asking. I leave the case open, leave the file open, going up on some of my reports, because it's already a year old.
Any act of yours, it's the court's.
I'm looking at the downside on this thing. What if she'd been convicted of it? Yeah, if she were convicted, would we deny the license? Yeah, I mean, it's a registration. Simple possession.
They've been really good about sending us updates every time she goes to court. I mean,
Acronym for controlled, dangerous.
Would you rather close something like
Page
that?
change before I can read that. No worry.
Normally, what we do, we do close the applications in case we don't.
Person down.
I think the question is, do we want to hold this open? Do we want to grant the registration, or do we tell her to reapply after it's been resolved one way or the other? Those are basically the three options we've got at this point.
Didn't the lawyer say that it was coming up soon? They were going to find out soon?
Madam Chairman, I make a motion that we close this application without any further action or without any prejudice, because the issue still remains in court. If they choose to reapply after it's been resolved in court, then we would take the reapplication and consider it at that. I'd like to see it closed because, again, I think it reflects unfavorably on the process. This has been held open not because of any board action, but I think after a year closing this, and like I say, without any prejudice would be the thing to do.
Okay, we have a motion by Mr. Roberts, a second by Mr. Harvey. All in favor, voice by saying aye. Aye. All opposed, motion carries. Close the application.
we had two, and then I.
Hardest one.
Well, the education's fairly simple. I gave Ken two courses to look at this morning. They're resubmissions. One of them is the Howard Constam's VIT CCTV course, and the other one is the 4-hour J Learning Locks and Strikes. They're both resubmissions. They were approved in '09. I don't believe there have been any significant changes other than they're required to resubmit them after July 1st of the year.
Madam Chairman, I have very carefully reviewed the materials submitted In the first instance, from Jade Learning for a 4-hour alarm classification in the burglar category. It considered is apparently a fairly comprehensive course in locks and strikes, door hardware, and related materials. This was intended, as I would understand it, for continuing education and employee training. It's marked here in both categories. Maybe we need to continuing education. I have no problem with that. I'll mark out the box that includes employee training, so we would be approving this, or I would recommend approval for 4 hours of continuing education category. Looks like a pretty decent course. I was going to recommend the two together. The second course I have is
Same company.
no, different company. Second course that I have was VIT Incorporated from Howard Constantam, and it is a CCTV course for they're looking for employee training, initial application, and continuing education. And it is a 16-hour course. I believe it would meet all of those classifications. So I would recommend it be approved as.
Okay.
So I would recommend both of them approved as they have been submitted.
You should make a motion.
I would put that in the form of a motion that we accept these two courses for the continuing education and categories that they have been submitted in.
Okay. Aye. Any opposed? Motion carries on those two.
Item I have is a degree, which is I don't know if it's acceptable or not. So the amendment itself, as far as the language, is on top. I recently got his transcript. I do not know if he'll be one of our applicants that wants to come here and test, but we need to determine if that's acceptable under your amended statute. Name, sorry, is Wadi George Andrawos. His application
I'll forget it while you're talking about computers and engineering and all that stuff. The bills that were passed that you just emailed to us about the locksmith and the alarms and where we were going to have to start taking education from military. Anyway, who brought those
Talking
up.
about.
Yeah, we got it. It's the military preference that's going kind of.
Something about if you just worked for four, okay, never mind.
That's good. I wasn't doing you that.
I was just going to ask who
Go ahead.
brought them up, who proposed all that, who got it going, got the ball rolling on that.
I don't even know what
Like
you're
if
talking
you work
about
for
about
4
the
years as a
military.
registered employee, that you
It was-
automatically going to be considered a locksmith? And
What?
You sent it to us.
I did not.
Yeah, you did.
No, ma'am. It might have come from the website, from the department. They've been sending things out and people have been
came under
calling
your
on
name.
it.
Anyway, we'll do all
It had
this and
my
I'll
name
read
on
it to you.
Oh, okay, yeah, let's just finish this one, then we'll go.
I thought it was going to be an easy question. Never mind.
Is this QA application just for the monitoring category?
All he applied for, he works for a central station called National Monitoring. California, they have a central station in California and another one in Texas.
Given that particular scenario, I would personally feel very comfortable in accepting this as the educational requirements for the background. Obviously, they have to meet the other requirements, but
So we're going to accept it if they do as a...
I would accept this degree as a computer engineering degree with the understanding that this individual is applying to be a QA in monitoring only. Yeah. Now, if he was applying in other categories, I would have much stronger reservations. But these degrees would probably fit very well in a monitoring center. So I would recommend that this particular academic transcript be approved as meeting our requirements for a QA in the monitoring category.
We have a motion by Mr. Roberts, a second from Mr. Harvey, to accept the documents as printed, as presented in the education field for the background experience required in education. All in favor, voice by saying aye.
Aye.
All opposed?
That needed to include that this was for the monitoring category.
Sorry for the...
No, that's all right. But
Anyway, just include it in the motion that it is for monitoring. Or do we need...
Clarification in the way it was worded, because again, if this educational background was presented for fire alarms, for example, then it would not, in my opinion, be yes, voted in favor of it.
Okay, so what if he comes in a year from now and says he wants to add?
And
Got another, he's been with this company since '01.
okay, then
He's going to have to take a test.
I'd like to see it represented if that were the case. I really think it's unlikely. He's working for a monitoring center, and, I think it's highly unlikely. But that particular degree in engineering, in computers, looks very compatible with a monitoring center.
I'm a dig him. It was to do with the locksmith and the alarm in two separate emails, and it was telling that we were going to be accepting the background for military personnel that had equivalent of stuff like we just reviewed. And
Yeah, I
that-
remember the email.
And then if you were a locksmith, if you were just a apprentice
so, too.
and you worked for a locksmith for 4 years, you didn't have to worry about sitting for the exam. You was automatically going to get a
I sent
locksmith
you a
license.
copy of the amendments to our law.
These are state...
No, these are state
These are laws
bills that
were
are passed.
State, they're laws that were recently, I think they became effective on July the 1st.
Did you find them?
Not yet, but preference
Last
that they're
week.
giving
It
returning.
really didn't seem I didn't think, as far as the alarm industry is concerned, it really didn't seem unreasonable. It did indicate a military preference of some sort. I don't recall all the particulars, but there was an email.
But I don't, the military thing was okay. I didn't agree with if you're a registered,
To me when you get it so we can see what it is, because I think it might have website.
came from your email address, but they could have sent it through your email address, I imagine. They can do what they want to.
Or just
Same
send
thing.
me a copy of the email, let me, when you.
I got them both the same day.
Mail from anybody else, I automatically put in the spam category, so it had to be from.
Yeah, but it was from you. Because I thought it was going to ask me, was it going to be there? And at the time, I didn't know if my schedule was going to allow me to be here today.
What date did you get it?
Yeah, if I could find it, I'd know that too. But I'm thinking it was last week one day.
It was last week.
What day was it?
Been within the last few weeks.
It was it was within the last 2 weeks. I don't think it was last week, but maybe
It was at the beginning of last week or the end of the week before.
It was like it came out right around
And my
the first of
phone-
the month when a lot of the new laws took effect.
My phone
I was on
deletes them
vacation
after.
the whole first week of July. I was not even in the office.
It wasn't, it was during my vacation week, so it was the second week.
Oh, there's July
15, 14, 13, 12. It was the 12th, 11, 10, 9, 8, somewhere between the 9th and the 12th, somewhere in there. My phone automatically deletes them after so many days, or I can find it. It's outside in my car on my iPad. I have to run out there and get it
I'm just looking here through my
where I'm illegally
items.
parked.
While they're looking at that, let me ask, we had one case that we tabled earlier in the day. Has there been any additional action on that? You just move that forward to the next meeting, it'll be fine.
Closer. I think I can find it in my sent box because I don't have a lot of, don't send much email out of this.
So you're going to find that in your cent box because you don't have many cents?
Because I don't, yeah, right.
That's it.
Don't even
I'm
go.
up till the 11th, and I didn't send y'all.
Well, while you're looking at that, let's go to the
promise you did.
little unfinished business. I just wanted to give you an update on our computer system. We have been moving forward with that. I spent 3 days, was that last week? Last week, from 8:30. Really exciting. I've been trying for years to get a nice looking photo ID. Everybody looks the same, that little photo ID. Well, with this new system, and apparently we're going to be purchasing now I don't exactly know how all it works, but it's going to be a printer. The individual could go online, do a renewal, upload their photo. It shoots to us. If everything's okay, we push a button, it prints right out in the office in the printer. It already has the picture, it's already laminated. We don't have to do anything but mail. Really excited about that, but for the thousands that we do in a year, it's really going to be. One of the things we wanted the computer to do, especially for this program, if a company changes its address, we have to manually change every single employee that's affiliated with it. This program is supposed to, whenever the address changes for the company, it will automatically go over into each employee that is affiliated. They refer to it as a relationship, and it will change it. Put a company in violation for whatever, lose their qualifying, whatever their circumstances are. Anybody that has that relationship will be changed to that as well. The problem I saw was what happens when the company comes back into compliance, but they're assuring me that they can turn it back. If they turn it off, they can turn it back on. We won't have to manually be doing any of this. So, really excited about some of this. It will not be this year. We're still in the baby phases, but it's from what I understand, everything's been signed. They have taken, it's the same people that we already have, it's just like a 10-year more advanced program. They've taken all our information and they have reloaded it, and now we're taking those steps. We're really excited, especially with your program, as many as you have, that we have to manually do.
I don't think, well,
Do we have any new business?
do we have any more unfinished business? Do we have any new business? Thank you.
Whooped it again.